Good afternoon. I'm Matt Weiner, the acting chair and vice chair and executive director of the Administrative Conference of the United States, or just ACUS as we call ourselves. Thank you for joining us today. This forum comes on the heels of and builds upon our just concluded multi-day forum on underserved communities in the regulatory process. The original impetus for today's forum, though, was the debate within ACUS preceding its adoption of Recommendation 2021-1, managing mass computer generated and falsely attributed comments. Several important questions arose during the debate. What role should so-called public opinion play in the notice and comment process? What sorts of views, to use the term in the Administrative Procedure Act, should have a purchase on agency decision-making? And to carry forward a question from our last forum, what can agencies do to enhance public input meaningfully? ACUS Recommendation 2021 specifically reserved judgment on those questions. We've assembled two distinguished panels of academics, advocates, agency officials, and other policymakers to answer them and related questions today. Not all of our panelists, of course, will give the same answers. Today's forum, like our last forum, will yield important insights and information that I suspect agency officials will rely upon in their ongoing evaluation of their rulemaking processes. And I know that ACUS, for its part, will rely upon in carrying out its own advisory mission. Before we turn to today's panel, I'd like to offer a few thanks to my colleagues Reeve Bull, Jeremy Grayboyce, and Danny Shulkin for planning this forum, to our distinguished panelists, including our former vice chair, Sally Katzen, for giving us their time and expertise, and to all of you for joining us this afternoon and participating in the conversation. I'd also like to extend special thanks to our keynote speaker, the Honorable Tino Cuellar, the newly installed president of the Carnegie Endowment for International Peace, and previously a justice on the Supreme Court of California, and before that, the Stanley Morrison professor at Stanford Law School. It could go on listing the many positions he's held. ACUS counts Tino, if I may, among its very best friends. He has served on ACUS's council, and he has co-authored ACUS's path-breaking report on the use of artificial intelligence in federal regulatory programs. We're honored that he's made time for us today in his unenviably busy schedule. I'm now pleased to recognize another leading light in our field, Professor Carrie Colonnese of the University of Pennsylvania, the chair of ACUS's Rulemaking Committee, to kick off our first panel. Professor Colonnese brings to us his experience chairing the committee meetings from which ACUS's recommendation on mass comments arose. Professor Colonnese.
Thank you very much, Matt, and welcome to everyone who is attending today. Needless perhaps to say, rulemaking is an important part of the lawmaking function in the United States, arguably by volume, the principal means by which law is made in the United States today. But for many members of the public, rulemaking has been and still is a relatively hidden process. It's not part of really what is in normal civics education. We don't learn about it from Schoolhouse Rock videos about how a bill becomes a law and so forth. But there is a role for the public that's built into the Administrative Procedure Act and its rulemaking procedures through notice and comment. There are other ways for the public to be involved as well. We do know that on occasion, there are rules that elicit hundreds of thousands, maybe even millions of comments from members of the public. But as a general matter, and we have empirical research on this, the median number of comments per rule is closer to about 12. And the modal number of comments on agency proposed rules is 0. So there are opportunities, it seems clear, to think about the role of public input and enhancing the role for public input. And we're here in this opening panel of today's symposium on public input in the rulemaking process to focus on different forms of public input and how it can be useful in crafting agency rules. I also want to note that this is a timely issue. The president has issued an executive order calling for greater attention to equity and inclusion in rulemaking. There's interest on Capitol Hill in these issues. In fact, just today, a subcommittee hearing in the House Judiciary Committee was held on the Administrative Procedure Act, and some of these questions arose there. And as Matt has already indicated, ACUS has an interest in both rulemaking and public participation in it. As he mentioned, this session builds on some very recent work, recommendation 2021-1 on managing mass comments, computer generated and falsely attributed comments. It also builds as well on ACUS recommendation 2018-7 on public engagement in rulemaking. And as Matt noted, I chaired the rulemaking committee and developed, as in full disclosure, developed the recommendations that led the committee in developing recommendations in both of these areas. And Danny Shulkin, the attorney advisor tasked with recommendation 2021-1, has also been instrumental in organizing today's dialogue. And I want to thank her for her leadership role. We're here in this first session to consider questions about what it means for the public to provide input to an agency. What is public input? What purpose does input from the public serve? And what types of public input do agencies, courts, the legislature, or the public perceive to be useful? And I'm really excited and pleased that to sort through these questions, we have 4 distinguished and expert panel members. Sally Katzen is the professor of practice and distinguished scholar in residence at NYU Law School, and she is the former administrator of the Office of Information and Regulatory Affairs, as well as formerly a deputy assistant to the president for economic policy and deputy director of the National Economic Council in the Clinton administration. And before joining the Clinton administration, Sally was a partner in the Washington law firm of Wilmer, Cutler, and Pickering. And she is currently a senior fellow with the Administrative Conference. Our next panel member, Sabeel Rahman, is senior counsel to the administrator of the Office of Information and Regulatory Affairs. He's on leave currently from his faculty position as an associate professor of law at Brooklyn Law School. And previously, he served as president of Demos, a think tank dedicated to racial equity, economic inclusion, and democratic participation. Our next panel member, Nina Mendelson, is the Joseph L. Sachs Collegiate Professor of Law at the University of Michigan Law School, Go Blue, and senior fellow at the Administrative Conference. Previously, before joining the faculty at Michigan, she served as an attorney with the Justice Department's Environment and Natural Resources Division. And last but not least on our panel, Amanda Neely is currently the Director of Governmental Affairs on the U.S. Senate Committee on Homeland Security and Governmental Affairs. And she also serves currently as General Counsel to Senator Rob Portman, and previously served in other positions on Capitol Hill and clerked for the DC Circuit Court of Appeals and practiced law with the Washington office of Gibson Dunn. She is a liaison representative to ACUS today. I want to thank you, Sally, Sabeel, Nina, Amanda, for being here today. For members of the audience, I just want to alert you that we are going to start with some initial conversation with the panel members, and then we will turn to questions from you. And there's a little button down at the bottom of your Zoom screen labeled Q&A, and you can press that button and enter questions in there that I will be able to see. And I will try to pose as many of the questions from the audience as I can to the panel members. So those are our ground rules for how we will proceed. let's get to the conversation. And Sally, if I might start with you and invite you to tackle some foundational questions for us. Would you, to get us started, offer kind of a big picture view of the role and the value of public input in the rulemaking process? In particular, is rulemaking a plebiscite? If not, then how should agencies view the contributions that the public can make in the rulemaking process?
Well, thank you, Carrie, and thanks to ACUS for assembling this stream of symposia and seminars. I think it's serving a very useful function. And now Carrie wants me to talk big picture, say 3,000 feet, public input in notice and comment rulemaking. And I guess you're basically asking, what are the theories? What's the value at stake? What's the practice? What's the potential? In a few minutes. So let me start, particularly for those who are not crazed administrative lawyer types, and there must be somebody in this world that doesn't live and breathe this stuff. You start with 553 of the APA, which is fairly simple and straightforward. Agencies are to provide notice of what they intend to do, and that's only fair to those affected, that they get a heads up. And agencies are to afford interested persons an opportunity to comment. They, especially those on the ground, may have something to contribute to the decision-making process. Now, over the years since 1946, when the APA was enacted, the courts have fleshed out, or some would say dramatically expanded, these skeletal requirements. So now the agency's notice not only has to say what it is thinking of doing, but why. And specifically, the agency has to lay out what data or studies or analysis it is relying on to support its proposed cause of action. And the rationale for this was that commentators would be able to meaningfully critique the basis for the agency's work, either affirmatively support and collaborate it with additional data or studies, or dispute it by challenging the methodologies used or providing different, contrary studies or data. And as the nature of the agency's notices changed, so too did the nature of the comments that were filed. Longer and more detailed filings became the norm, often with voluminous reference materials or original studies attached. And in one respect, this was a very good development in that one of the purpose of comments is to educate the agency. And all this material can provide additional resources for the agencies. Another purpose of the, or objective of the comment period is to encourage buy-in. If you participate in the discussion, so to speak, and the agency has to consider your data and say why it accepts or rejects it, then you're more likely to cooperate, which is very important in the regulatory world because there is no enforcement officer on every block, assuring that regulatory agencies fulfill their responsibilities. But not all who are affected by a proposed rule have either the incentive or capacity to prepare and submit detailed comments. I'm referring here principally to the intended beneficiaries of the proposal. There are some NGOs that do a very good job, but the man or woman in the street who lives or works next or lives next to or works in a particular factory has been conspicuously missing from the discussion. Now, somewhere along the line, someone got the bright idea of generating public support or opposition via postcards or Xerox copies of form letters, expressing enthusiasm or outrage. And these manifested themselves later in mass emails to the docket. but how to know if they're real or if they're truly representative of public opinion? Then we had those who shouted, "Wait!" They were upset with this development. Rulemaking should be data-driven, not a plebiscite. We are not taking a vote. And that was the crux of the debate that led to this panel, actually. And Richard Pierce from GW is just adamant. It is not a plebiscite. I wish he were here so I didn't have to channel him. But let me say, no one thinks it's a plebiscite. We are not arguing it is a plebiscite. We are not taking a vote. But those cards and letters and emails that people were motivated to send may have something to contribute. Remember, I mentioned the contribution of those on the ground and buy-in by regulated entities. Their data-driven analysis is essential to good decision-making, but it's not sufficient. A corollary of what they are looking at is public acceptance of the proposal. If it is perceived as not solving the problem, or even if the intended beneficiaries don't have confidence it will solve the problem, then it might never really get off the ground. And old timers, there are some of you out there, may remember DOT's ignition interlock rule for seatbelts, which died a very quick death in public opinion and shortly thereafter in Congress. The younger generation need only look at mask mandates. I will say no more because I will otherwise get in trouble. So without treading on the topics that the other panelists will want to discuss, let me end by saying that there's a lot of space between data-rich comments and a plebiscite. And there are opportunities in the rulemaking process beside the 553 notice and comment to accommodate increased public participation. Thank you.
Thank you very much, Sally. And if any panel member does want to argue that rulemaking is a plebiscite, I certainly invite you to do that. Let's turn to Nina, if I may. Sometimes with the kind of outpouring of public support that Sally referred to in the ignition interlock case, or mask mandates, or net neutrality, we do see a large outpouring of emails and public expressions of views. And sometimes people worry about embracing public input and encouraging public participation, because it might mean that agencies become flooded with lots of public input that contains little by way of substance, and maybe the agencies really don't even know what to do when they're inundated with these comments. Can you help us understand, do you think these worries are valid? How do you think agencies should respond? Are there instances when these type of mass comments in particular might be important?
Yeah, well, first, thanks so much to ACUS for putting this panel together and for including me on it. I'm very pleased to be part of this discussion. And of course, as you already mentioned in your opening remarks, we sometimes do in some rulemakings, by no means all, get large volumes of comments pouring in from ordinary individuals. And some commentators have been dismissive of these kinds of comments. I just want to acknowledge that there are occasionally, if you will, clunkers among individual comments, as there are no matter who submits them. I once found an uploaded credit card statement on regulations.gov. Amanda, I'm sure she'll talk about it in more detail, led a report identifying comments that at best have to be understood as coming from internet trolls. And we still do see Occasionally, I think one sentence statements along the lines of the postcard campaigns that Sally alluded to, one sentence in regulations.gov that says, I support this rule or I oppose this rule. But I do want to emphasize that lots and lots of comments coming in from individuals include statements of reasons why people hold the views that they hold and reports of their personal experiences. Right now, there's an open docket on the Dreamers policy, and lots of individuals have filed very thoughtful comments and reports of their own needs and preferences in that comment period. So why might this be relevant? Everyone agrees that rulemaking can't be a plebiscite, if nothing else, because agencies function under a statutory mandate that tells them to take into consideration lots of issues. Public views have never been the only issue that an agency could consider, but there clearly are lots of times when public views are going to be relevant to the policy issues that an agency has to resolve. So I thought it might be useful for me to just provide a couple of examples on this. There was an Americans with Disabilities Act rulemaking that considered the importance of nearby accessible bathrooms to wheelchair users and the dignity of wheelchair users. Comments from individuals are going to be of obvious value here as the agency assesses essentially the importance of a policy like this. Comments can alert an agency that a mandate is going to face serious public resistance, perhaps because it's too burdensome or paternalistic along the lines of the ignition interlock that Sally mentioned, or it could also be the wrong use of a shared resource. Here, I would just share a story from my own part of the world. Michigan, right? A few years ago, the Coast Guard decided that it would create live fire zones in the Great Lakes for weapons practice. They thought this was a good idea. They thought it was justified. They thought it was not too risky. They did not put the proposal out for public comment. If they had, they undoubtedly would have detected the substantial public opposition that ultimately just halted the project. People did not want this important shared resource used in this way. This is a function that public comment appropriately serves and usefully serves, I think. One last example, environmental justice. There's an issue pending right now under the National Environmental Policy Act about whether agencies doing environmental analyses need to think about cumulative impacts. This is especially going to impact low-income communities and communities of color. And again, an example from my area, Southwest Detroit, where residential neighborhoods are placed alongside multiple polluting sources. Okay, so to be clear, this is not a technical issue. This is really a policy question. And the policy question is, do the community quality of life concerns outweigh the burden, if you will, of longer environmental analyses? How important are these issues? Are they important enough to justify asking agencies to do a more in-depth analysis that considers cumulative impacts? Community views that individuals have an opportunity to submit through the comment period are clearly going to be relevant to this agency decision, and I think important to this agency decision. So that's just a few examples. Comments will not be relevant to every single agency decision that's put out for public comment, but they're going to be relevant to many. I think the door is open for public comments, and we really need to recognize their importance. So what should agencies do with them? I'll just say, when I first started working on this issue 10 years ago, agencies seemed frequently to treat these comments with short shrift. They might not offer any response at all beyond saying, we got a lot of comments. I think that's not the right approach. Agencies should take large volumes of comments coming in from individuals quite seriously. They can't serve as a plebiscite, but we could think of them, or perhaps agencies could think of them, as a little bit like a yellow traffic light, right? They might prompt an agency to pause. Perhaps an agency might actually recognize that there's a significant number of people with particular experiences they hadn't considered. They might consider outreach to a particularly affected community and investigate those issues more deeply. The public comment process could prompt that kind of action. At a minimum, I think it is appropriate and feasible for an agency to offer a brief answer, at a minimum, to issues raised in comments. Even if an agency does receive a lot of comments that are like the old postcard campaigns. They just state a simple preference. The agency could at least acknowledge their receipt so public commenters know that they're being heard. Now, I'll just say happily, I think more agencies are systematically taking individual comments quite seriously now. And I think that's a great development. So, even in the net neutrality rulemakings during both the Obama and Trump administrations, the FCC acknowledged the comments it received, and the Labor Department recently issued new regulations under the Fair Labor Standards Act for jobs where customers tip, the tip regulations, and they recognized and responded to numerous issues raised by individual commenters, both employees who worked in jobs where customers tip and employers of those people. So I think that's a great development, and I'm hoping that that will be the norm, that agencies will respond to these comments. Agencies already respond systematically and thoroughly to comments filed by trade associations, regulated entities, nonprofits. They should also acknowledge and engage significant issues raised in comments that come in from individuals, even when they arrive in large quantities.
Well, and to that point, and maybe to make it a little more feasible for agencies to engage in that kind of response, I would just make a plug for the work that ACUS did in leading up to and developing Recommendation 2021-1, which is all about managing mass comments, computer-generated comments, falsely attributed comments, so that it is easier to handle an onslaught of large volume of comments and to be able to process them meaningfully and respond to them. Sabeel, if I could turn to you. Right now, we have, up until now, we've been talking a lot about commenting and the part of the 553 process that's part of the Administrative Procedure Act for the public to provide input. But you're at an office that has something to do with rulemaking and yet isn't in the APA. So there's other aspects here of public input, and I wondered if you could focus our attention on when and how public input can take place beyond just submitting comments on proposed rules. And do you see there might be any particular value, for example, to early input before a proposed rule is issued, or perhaps some value even after a final rule has been issued?
Yeah, absolutely. And thanks again to Carrie and ACUS and this great panel. It's great to be here with Sally, Amanda, and Nina. So just picking up on that theme, I think a lot of the examples actually that Nina just shared really apply more beyond just the notice and comment period itself, right? So if you think about all the policy judgments and all the different types of information, quantitative and qualitative, that go into designing a policy before it becomes the many hundreds of pages of reg text that we see published in the Federal Register when it goes out for comment. There's a lot of judgment calls that need to be made at that early stage. And I think one thing that is really interesting to think about, there's a lot of, I think, need and desire to do more, is to think about how do we engage particularly affected communities, and in particular, those beneficiaries or impacted communities that Sally mentioned, who might be underserved or might be traditionally not able to engage in sort of traditional notice and comment. How do we find ways to engage those constituencies upstream from when a notice and comment goes out, when the agency is thinking about its overall design strategy for that policy, how it's going to implement a set of policy choices, right? If we think, for example, on service delivery of various kinds that many agencies do, really vital services, lots of design choices go into, what kinds of forms do people need to fill out? What might be the administrative burdens that might be perhaps unnecessary or create downstream effects that make it harder for people to get access to the benefits they need to get to. There are a lot of design questions that, some of it might come up once it goes out for comment, but that, especially if we're talking about engagement from constituencies who might not be bringing tons of data, say, or a well footnoted report, that input might actually be more impactful and more helpful early on in the process. So I think that's one piece to really think about. The second piece is then after, once a rule is finalized and out in the world, how do we create systems to learn from what's happening on the ground and make improvements over time? And so I know there's lots of interest starting from a couple of years ago, right, in retrospective reviews of regulation. But I think public engagement is a part of that, right? Are some of these policies that might be designed to say, have an impact on a particular community-facing pollution, or some of these service delivery programs that I mentioned, is it actually reaching the people who we need it to reach? Are there other implications that weren't thought about, or that might have been assessed in one way when the rule was proposed, but it turns out that once it's out in the world, we're seeing a different kind of impact? Right? Those are things that we want to learn from, and I think good policymaking sort of requires some good channels for doing that. Public engagement, I think, is important to that too. The last thing I'd mention, and there's lots already to talk about for all of us, is I also think it's helpful for agencies and just for all of us who care about this to be thinking about what's the right mechanism for engaging with these communities, right? We sort of have our standard open government toolkit, right? Put things out for comment. Maybe there's a town hall meeting of some kind and so on. But for folks who do work in organizing and civic engagement, sort of wearing some of my earlier hats from before this particular job, one of the best practices in civic engagement is actually the need to work with communities where they're at, right? To work with trusted intermediaries and whether it's nonprofit organizations or locally embedded organizations, to find ways to proactively engage with communities whose voice we need to hear from, right? The kind of passive open door works for those who have resources and sophistication and know-how, but doesn't always get you the full range of voices and input that we might need to hear. And also, I think to the point of about mass comments and worries about sort of that we don't want this to be a plebiscite. I do think structured engagement that is more proactive, right, also changes the tenor and quality of the discussion. Right? If you're convening stakeholders in a particular way, depending on how you set it up, you can actually get much more detailed information than what might be on a postcard, but actually get some nuance and sense, especially if we're talking about the kind of value judgments, say, involving human dignity or involving complex trade-offs between, health and technical issues that might come up in an environmental justice context, say, that Nina mentioned. So I think it's both the upstream, downstream, sort of when do we engage, and also the how, right? Getting above and beyond the notice and comment vehicle.
Yeah, that how it makes me, think about the body that Amanda works within, the what has been called the greatest deliberative body in the world. We'll leave for another discussion whether that's true still today, but certainly it's true that Congress, both houses, provide opportunities for the public to provide input to their elected legislators about many issues, some of which include agency rulemaking. So Amanda, if we could turn to you, a couple of years ago, you led a subcommittee staff report on the public comment process in rulemaking. Can you tell us what you learned, what lessons you draw from the work you've done and the work that you do within the legislature about how public input can inform the rulemaking process? And in particular, do you think there's a role for Congress here?
Thank you so much, Carrie. I really appreciate it. And thank you to ACUS for hosting us here today for this exciting discussion. I always enjoy this topic. And I will offer the standard government caveat that all the opinions I express today are my own and not necessarily those of Senator Portman or the Senate or the Senate Homeland Security and Governmental Affairs Committee. I previously had the real honor and privilege to work on the Permanent Subcommittee on Investigations, which is just this great subcommittee that allows staff to sit around and think for a long time about big problems and research them and investigate them and produce reports on them, and then hopefully write legislation based on those reports. And if anyone has been following this saga with any attention, you'll see that there's not new legislation on this particular problem that I'm about to talk about. And I would love to open the floor to our everyone here today, our audience here today, if you have suggestions about how to address some of these issues without trampling on the First Amendment and without harming the ability of individuals and groups from submitting their legitimate comments. And so, and let me back up there a little bit when I talk about the vocabulary is, I'll use legitimate, but we can see if there's a better word for it than that. So this opportunity at PSI gave me the chance to look back at the foundations of the Administrative Procedure Act. And I found this report from 1939, or well, it was a directive from President Roosevelt in 1939 to his Attorney General. And he said that his Attorney General should look into how the regulatory process worked and how they could improve it. And his Attorney General produced a report in 1941. And it stated that knowledge is rarely complete and it must always learn the frequently clashing viewpoints of those whom its regulations will affect. And I'll paraphrase the rest of this. Participation by the groups of people who are affected by regulations in the rulemaking process is essential in order to permit administrative agencies to inform themselves and to afford adequate safeguards to private interests. And the report instructed that agency procedures should be adapted to giving adequate opportunity to all persons affected to present their views, the facts within their knowledge, and the dangers and benefit of alternative courses. And I really appreciated that that was what underpins the APA and what I think has been the driving force behind a lot of our thoughts about regulatory legislation going forward, that people, everybody who's affected by rulemaking should have the opportunity to participate. And I firmly believe that. And I think that was the belief when we came into the internet age in the early 2000s, and we started moving toward online commenting. And then in 2004, though, there was a really great article by Emory professor Beth Novick at the time. And she had written a little bit of a caveat, which was increased network effects may not improve the legitimacy of public participation, for without the concomitant processes to coordinate participation, quality input will be lost. Malicious, irrelevant material will rise to the surface. Information will not reach those who need it. So we now have these competing issues here, getting comments from individuals who are affected by regulations. But then, as she notes, malicious, irrelevant material on the other hand. And so whenever I talk about these issues, I want to be very, very clear that when I say legitimate comments, I think that individual comments from everyday people who might have a regulation that affects their city or have an experience like the Dreamers who want to express their feelings about coming to America and their experience here in America, I think those certainly qualify on the legitimate side. But then what we have seen, I think, bears out some of Professor Novick's 2004 concerns. And as Carrie noted, lots of regulations don't get any comments at all. Some get 12. That's kind of the norm. But what we are starting to see more of are some regulations that are getting millions of comments. And that would be okay if those are millions of Americans wanting to weigh in individually and say, I have a problem with this regulation, or I think this regulation is great. But what we have started to see is that these are not necessarily comments that are being submitted by individual Americans with a sincere thought on a rulemaking. Some of these are comments that are being submitted by bots. They're submitted by large interest groups that have membership lists. They'll submit the comments from their membership list without the individual members knowing that they're being submitted on their behalf. And that's less, at least, sincere engagement. And then, and even worse, in some cases, we've seen people having their identities stolen and comments submitted under those identities. And so if Joe Smith has submitted a comment, and that's probably a bad name to use, given that would be maybe lots of Joe Smiths out there. But if Joe Smith, who lives at 101 Deep Creek Road, submitted a comment, and that Joe Smith said, well, actually, I believe the opposite, and I don't want to have anything to do with this regulation, then we've got a problem. And and it's very unclear what we need to do about this. We saw this problem really emerge in the net neutrality rulemakings, and that's what led to our interest in this topic at PSI. We saw in the Restoring Internet Freedom rulemaking, which repealed net neutrality, there were 24 million comments submitted. That would mean that they would be the equivalent of every single citizen of the top, I think it's 12 cities by population in the United States submitting a comment on this. Then Pew Research found that about 500,000 of those comments, which is about the size of Atlanta, 500,000 were submitted by bots from Russia. That is a real problem. So when we talk about data-driven analysis, which I think Sally and Nina were talking about, you want to go through and look at those 24 million comments and analyze those comments on pro versus con on this rulemaking, which lots and lots of people did. That would be great, except for those flags are being thrown up by Russian, some of them are being thrown up by Russian bots, not by American citizens. And do we want to be taking into account what Russian bots are saying, like an Atlanta-sized city worth of Russian bots? And I think the headlines from that time kind of bear out those concerns. A Slate headline from 2019 stated, "A broken system helped FCC kill net neutrality. It afflicts the whole government." And the Washington Post, the headline, "Fake comments flooded in when the FCC repealed net neutrality. They may count less than you think." So these fake comments are really undermining the system and this trust that we would hope American citizens could have in the rulemaking process. That was the FCC. The FCC has one of the more robust systems called the Federal Document Management System for accepting comments, and they make it a policy to accept anything that people send, up to and including, I think at one point, executable files that if people then open them, it would download a virus onto their computer. Also including things like the entire copy of Les Mis or a whole movie script that are just abusive comments. These are individual people, and maybe the entire copy of Les Mis has some relevancy to how they feel about their government or net neutrality, but most likely they were doing it to try to overwhelm the system. And I'm picking a lot on FCC, as I said. Another good example, in December 2019, is a publication called TechCrunch. And they wrote an article about how they submitted 1,001 fake bot-generated comments that sounded like human speech to CMS about a rulemaking on regulations.gov. And that comprised more than 55% of the comments on one rule. And in a follow-up, so those got through, no flag. And in a follow-up study, they had average people guess which of those were submitted by real people and versus bots, and they only got it right about half the time. So it's basically a coin flip. So the technology is good enough that it actually sounds like people submitting these comments when it's not. So that comes into the problem of what do we do about this? And I spent a lot of time thinking about this and got lots of comments back on drafts of proposals. And lots of people had concerns that it would stifle regular American citizens from commenting on rulemaking, or that it would potentially violate the First Amendment. We don't want to do that. So we took a step back and we've been tracking it since then. We think the agencies have taken some steps in the right direction. They've instituted reCAPTCHA on regulations.gov, I believe, which reduces the ability of bots to post comments. They've hosted some gatherings to talk about how to reduce fraudulent comments and how to improve the system. ACUS has done a lot of good work on this front. But I think it would be great to hear views from other people and see if there are ways that Congress can help out to bring online commenting into the modern era.
Excellent. Thank you very much, Amanda. And let me build on that last point and invite members of the audience here. This is a session on public input, so we value your input. And I want to remind you you can post your questions in the Q&A function down at the bottom of your Zoom screen, and we will try to get through as many of them as we can. Let me turn to the panel first and see if anyone has any responses to what others have said? Are you inspired to add some more? So Sally, let me turn to you first.
Well, thank you, Carrie. And I mostly want to associate myself with Sabile's comments. But as background to it, I want to emphasize that not all agencies are the same. And not all issues are the same, which is one of the reasons why when you think about legislation, it's very hard because your mind immediately goes to the outlier, immediately goes to the agency that this is going to totally mess up, or that this is going to be totally unproductive. And having said that agencies are different, that leads me to someplace that Sabile was starting to go, which is the consulting early on. And that's done not by OIRA, but by the agencies. And that's an outreach as they're thinking through how to craft the notice of proposed rulemaking. What really is the problem? What really will help solve that problem? And I stress it in those terms, that they need to talk to the regulated beneficiaries. They need to be proactive in Sabile's terms. And let there be no mistake, this isn't favoritism to the disadvantaged by any means. Every regulated entity, when it knows that an agency is working on an NPRM, goes running into the agency with all of their materials, talking points, and whatever. And they try to influence how the NPRM will come out. That's what the regulated entities do. So if we're not getting that kind of influx from the regulatory beneficiaries, then the agency, I think, should, in its infinite wisdom, look through the stakeholder list, look through its subscribers, or just go into the community and talk to people. And what strikes me as frustrating is that in Executive Order 12866 back in '93, and then in the Obama executive order, it talks about early consultation, early as in pre-drafting of the NPRM, early consultation with those who have something to contribute. I just wanted to kind of push Sabile's comments a little bit in that direction.
And so maybe the kind of concerns that Amanda was expressing and others have expressed about these fake comments or computer generated comments, in some sense tainting or delegitimating, even to a small degree, the comments that are coming in after the proposed rule. Maybe what the one implication of this should be to really emphasize to agencies, that is all the more reason why you need to do more to go out there and get genuine feedback and input. And, in the spirit of the Senate and deliberation, actually not just be able to receive a comment on a one-way basis, but engage in some kind of deliberation with the folks who are really going to be affected by this regulation.
I seriously doubt that bots will show up at a town meeting.
Yeah,
agree with that, but there is actually a really interesting point about that, and I think we saw it under the Obama administration and the Trump administration, situations in which agencies had a preconceived notion about how they wanted to approach a problem, and they would reach out to people that they would know would support their particular view and say, hey, we're going to put out a rulemaking. You should comment on this rule and talk about how much you support it. So they're lobbying, they're going out there to lobby to gin up support among the public. So I think that's another really interesting aspect of this. So you have to make sure that town hall is not just planted with people who are there to support the rulemaking or oppose the rulemaking, but also really talk about their genuine interests.
Genuinely open. Yeah, Nina, you're next.
Yeah, so I just want to chime in on a different issue that Amanda raised, which is this. I mean, the issue really is about the integrity of the rulemaking process. And I have to say, I do think we should have concerns about large numbers of bot comments, large numbers of fake comments. And I think the New York Attorney General has a great report on the most recent net neutrality rulemaking and how many of those comments, several million of those comments, were tainted in one way or another. And it's absolutely right that these rulemakings are rare. They're rare both in the high volume of comments and in the presence of large volumes of tainted comments. So they really aren't typical, but I think we should be concerned about them because I think what the public thinks about a process like this is going to affect the way they see the process more generally, even if our more typical processes are really not affected by these. So I think that does make it incumbent on the agencies to take more steps to make sure the process has some integrity. I think recaptchas are great. I think maybe people could also be reminded that it's not legal to submit false statements to the government. They could just be reminded of that. That might deter some of these comments. But certainly that would be a positive move. My concern about these kinds of conversations, though, is it has led some people to say, we should just stop encouraging individuals from sending in comments. And I think that would be a serious problem. So I do want to make sure we don't cross over and go that far, because I certainly want to associate myself with Sally's point that regulated entities typically punch way above their weight in these processes. They are very, very well represented, and the people we are not hearing from are regulatory beneficiaries, individuals who don't have organizations to represent them very well or don't have the resources to participate in this process.
Sabeel?
Yeah, just one last thought to add. This is great discussion. I think on that score, another dimension of this is also it takes a certain amount of infrastructure, right, and capacity to pull this off, both on the part of civil society groups and on the part of government institutions as well, right? There is an expertise and a certain amount of resourcing that's needed for agencies to be able to do that kind of effective, proactive engagement. It's a skill, right, to design those types of whether it's meetings or forums or input sessions, advisory sessions, what have you, right? That's a skill as well. And I think we want to see more of that. I think it's also helpful to maybe think about what kinds of skill sets, talent pools, budget and other resources agencies might need, and then what types of organizations might we want to see in civil society to help bring those folks who are not on their own able to engage in the way that I think everyone is talking about here on this panel.
So one of the questions that has come in from the audience draws a parallel to the SBREFRA pre-proposal process for rules that might affect small businesses, and asks if that kind of a structured pre-proposal process might be appropriate to have agencies engage in with a broader set of the public, not just small businesses. Should agencies be expected in some rulemakings, perhaps to develop in advance a list of draft alternatives and related analyses, maybe this may well require some resources from Congress to have support personnel, maybe to provide some reimbursement for travel for members of the public to participate in these. We do cover travel and time off for jurors in the civil and criminal courts. Maybe we need to have some kind of funding for engagement with members of the public in a structured process like this. What do people think of that as an idea?
I've got two quick thoughts on that. One, Senator Portman has long been a champion of Sally Katzen's favorite bill, the Regulatory Accountability Act. It is probably my favorite bill. It's probably not Sally's. But that bill does have some features that I think Sally probably also likes to some degree, including a notice of initiation of rulemaking for some of the larger rules. And the idea behind that was to be even NPRMs, frequently notices of, or ANPRMs, advanced notices of proposed rulemaking, can sometimes have the agency's solution kind of baked into the problem. And the idea would be to back that process up even further and say, here's the problem. let's go ahead and open up the floodgates to getting crowdsourced information. So the RA incorporates that. It also has a retrospective review feature for some of the largest rules that would have a comment process associated with it. And it has a responsive comment period in it. And that was another reason, because I've worked on that bill for so long. That was another reason why this problem really interested me, because my thought process was sort of, to create this responsive comment period, how do people even go about finding the comments they need to respond to in order to have that be a productive process? So, and then regarding the funding, one thing I think the pandemic has, I wouldn't dismiss that out of hand, but one thing the pandemic has shown us is that we are able to get large groups of people together in a forum. It's not as ideal as being together here in person, but you could do a town hall Zoom meeting to talk about a particular regulation and probably get more participation. And I think that would open it up to, say, parents who can't necessarily drive somewhere or fly somewhere to go participate, but they can get on their Zoom for 30 minutes and have their voices be heard. So I think that's would be a productive way to add voices.
Sally?
The questioner was launching SBIFRA. I think the concept of early consultation with those affected makes sense. I think the model of SBIFRA is totally unproductive. With SBIFRA, very frequently, the participants are selected, much as Amanda was describing how agencies would talk about their NPRMs and get selected people to support them. SBIFRA is just rife with prepackaged participants. So I don't like the concept. I don't like the model of SBIFRA, and it applies to all sorts of things where it really was not the least bit productive. But I do like the concept of asking agencies to do some things early on, as I mentioned earlier. And that's why I not only was intrigued with, but supportive of some of the provisions that Amanda had crafted about early notice. I don't want to drop the later period, and that is post-comment period, when the agency is looking through what it has received, the extent to which there is an absolute reluctance to go out for another comment period because it's going to take too long, because right now rulemaking takes forever. And so agencies resist that. And I think one way of thinking about it is to try to frame the agency post-receipt of comments period in a way that might enable agencies to, if not get reply comments, but put out some summaries of comments or things they heard. And does anyone want to expand on that? So that you're, it's a way of an agency sort of inviting a second round. And let's not go into the logical outgrowth problem. And if the rule changes, there's all these other problems. I don't want to go there. But I do think we ought to be creative about what happens as the agency itself is summarizing the comments, which takes a long time. Can some of that time be used to solicit refinements on the comments received?
Could agencies be expected in their notice of proposed rulemaking? This would be a very simple thing to identify, required to identify concretely in some kind of structured form, even the issues or matters on which the agency would find comment to be particularly useful, or somehow to frame the notice to the public so that they can know a little better what might be helpful to the agency. That seems to me eminently feasible for agencies to implement and maybe for Congress to require, perhaps. Sabeel or Nina, did you want to comment on the points? Nina?
I can
Go ahead, Nina, I'll go after.
Okay, all right. Just quickly, I think agencies are already using these questions to try to frame comments. The OSHA vaccine mandate is also an interim final rule in which the agency has requested answers to, nine questions. So I think that's great and could be more systematically used. In terms of the reply period, it is a big burden on agencies to identify the kinds of issues on which they'd like more feedback, but I think it would be extremely useful if there is also a way, if you will, for commenters to work their way through the docket and identify, a particularly useful comment, a particularly problematic comment, so that the agency is not the only one identifying the issues that might deserve more investigation. I think that would also be useful, but it does kind of underscore the management challenges, that Carrie alluded to, of handling these large volumes of comments.
Sabeel.
Yeah, just to build on these, I think, experimentation is always helpful. It's hard to have a one size fits all for the kinds of, as a number of folks on the conversation already mentioned, right? There's lots of different types of agencies, lots of different types of actions, lots of different types of impacted communities. And so I think experimentation and tailoring will go a long way, but how can we help create sort of that impetus where that is the default, right? As opposed to these experiments being the exception. A couple of examples actually might be, I do agree with Nina, I think agencies are starting to experiment with some of these sort of post-rule or in-between rule, like let's hear from impacted communities. So when the executive order on advancing equity and reaching underserved communities came out, as part of that, a number of agencies, FEMA, for example, is one of them, put out RFIs just on equity. OMB did one too, but FEMA as an agency that's directly touching so many communities, actually did a separate RFI getting public comment on where are ways that administrative burdens might be reduced, where there might be opportunities to improve kind of equitable impacts and outcomes as a way of just thinking more holistically about strategy and policy going forward, right? So not attached to a specific rule making yet, but that was sort of I think a notable example or experiment. Department of Interior similarly put out a Federal Register notice on the America the Beautiful plan on conservation and wildlife, also sort of requesting input, feedback from the public about how to think about that issue to operationalize strategies for future work. And I think those are interesting nuggets, right? Where they're sort of in between individual actions, they're sort of high level. So to me, that's similar to the kind of upstream pre-rulemaking phase that we were talking about before, where it's really inviting ideas on how to think about a set of value judgments and trade-offs and ideas that could then eventually become rules, right? And so I just offer those up as extra examples where I think giving some more oxygen to those types of experiments, I think could really be helpful in this work.
Amanda, did you want to follow on any of these comments at all? I mean, and maybe one thing, if I could, ask if you would want to comment on it. Have you found in this conversation some suggestions for legislation yet? Would you, and maybe even more pointedly, think that Congress could productively use ACUS recommendation 2021-1 as a framework for model legislation to require what I would call more of a management-based approach to this issue, that is calling upon agencies to develop, and this could be tailored to their specific circumstances, but to develop some agency plan and procedures about how to manage and be able to sort the wheat from the chaff, if you will, manage the public comment process, but maybe also to develop strategies for how they could promote and enhance public participation, whether through early input processes, better notice in the proposed rule. These seem to be possibilities if agencies had the sufficient impetus from legislation, maybe sufficient resources to help them, would be probably modest resources, I think, necessary. But anyway, does this seem, anything in here seem to respond to your call for suggestions on new legislation?
I think so. I think I have to go back and think through before I commit to anything here. But no, I think ACUS's work has been really, really valuable on that front. And it's something that is worth spending more time on. I like the idea of not only because it saves me some work, but putting some of the work on the agencies to offer some solutions to the problem. And I think that your observations that different agencies are different and different rulemakings are different. So I think that there might be some creative ways to deal with it. We were talking in our preparation for this panel the other day. I was noting, we all agree it's not a plebiscite, but there was one really interesting rulemaking a few years ago when the administration decided to try to raise park fees for the national parks. And at that point, they were going to triple the park fees. And at that point, there was this outpouring of families and individuals who said, these are our national parks and we can't afford to take our kids there. If you raise the fees so much, and the administration saw that, and it really was just a huge not necessarily a plebiscite, but maybe it's more like the yellow flag on the play, but they really did back down from that. And that's a very different rulemaking from a highly technical specific kind of rulemaking. So I'm not even sure how you would categorize the two different ones or where those lines would be drawn, but I think it's worth thinking about that too.
Let me pick up on the point about a lot of rulemakings being highly technical. And, we do have some folks here who've spent some time or are still spending some time at OIRA, which is often viewed at least from the outside, as the place where the technical analysis gets a real look over. And we do have Executive Order 12866, which incorporates this process for regulatory impact analysis, benefit cost analysis. Has this process, how does this factor into this discussion? I guess there's a couple of ways I would invite anybody to comment, but certainly Sally and Sabeel, if you'd like to. One is, what's the role of public input at OIRA? And is that, something we should be putting out on the table? Two would be, does cost benefit analysis crowd out the kind of public engagement and the value of public engagement? Or maybe benefit cost analysis systematizes it. I'm thinking about, in particular, Sally, you've talked about the voices of the regulatory beneficiaries, and in a contingent valuation process of surveying members of the public to elicit their preferences about certain, non-market values that are affected by regulation. It's a very systematic way of, it seems to me, of engaging what the public thinks and how it values certain benefits from regulation. Maybe benefit cost analysis is actually a way, actually a vehicle in some cases, of getting a more systematic representation of public views on some matters. So anyway, I would invite some conversation about this connection between, on the one hand, what seems a technocratic process of benefit cost analysis, OIRA review, and what we're talking about in terms of democracy, deliberation, public participation.
Well, there's a
Sally?
piece of it that I have been enamored of, and that is benefit cost analysis or cost benefit analysis looks at the total sums. What are the benefits? What are the costs? It doesn't look at who bears the benefits or who bears the costs. Some of those are fairly easy to discern when you look at the issues, but others are less so. And so it seems to me it's very important to be able to deconstruct, particularly on the benefit side, how this is going to play in real life. And the other thing is that I worry, as I said in my opening comments, I worry that benefit cost analysis goes to an analysis of the proposed solution. I'm still stuck on, have we correctly identified the problem? And have we correctly identified the feasibility of this solution in the community where the problem resides? And I think unless you deaggregate or disaggregate, or I don't know what the term is, the cost benefit analysis, and you run this in addition, I think you're going to miss the boat. I think you're going to make it more formulaic and more mathematical and less human. Sabine may have a different take. I don't know.
No, I love that. I mean, I think, so going back a little bit, when we were talking about sort of when participation might be helpful or differently helpful, right? I mean, I do think some of these questions really do need to feed in that early stage thinking, right, that we were talking about before, for a lot of the reasons that Sally just mentioned. And then ideally, right, you have a set of policies that then are tailored or developed with a fuller understanding of what the problem is and what the range of options ought to be, right? And then that's what comes to OIRA, goes out then for public comment and so on. Obviously, OIRA has a process that ACUS folks are well familiar with, and welcome input through that process. But I do think it's a different, the policies just at a different stage, right, when it comes here, and that's just a different, the questions that are being asked, the things that are already sort of in place versus, it's just a different part of the life cycle of, how a law becomes a reg or how a reg becomes a policy. So I do think that upstream part is still really important. And then ideally that should flow through what agencies have heard from communities and stakeholders, should flow into an impact analysis, and then should be shaping, the policy choices that are made. And then, be assessed afterwards, as we talked about as well. The other thing that your question, Carrie, makes me think of is, I do think, Sally mentioned the distributional or disaggregating some of the impacts. I do think that's really important. I think as part of OIRA's role is that coordinating of review, and has the agency considered all the various factors and so on. I think it's an interesting question of how do we help look at this piece, which is more of a process question of, have you engaged as the agency with various stakeholders in ways that are sort of most useful, right? That's sort of an interesting question too, to think about. How can the review process help support, facilitate, catalyze those types of engagements as well? But while I think leaving a lot of this really has to be tailored, I think, by the agencies.
We have just about 2 minutes left, and I'd love to get very quick answers from each of you on a final question. Actually, it's a final 2 questions, but I'm going to package them in one. One question is, what are your thoughts on the potential impact of Little Sisters on public input in rulemaking? I don't know if anybody here is prepared to really talk about the Little Sisters case here. So let me reframe that as, is there one thing about the administrative process or administrative law that you might recommend we consider in helping to improve the public comment process? And the last question actually is is what is the one thing you'd like to see to improve the public comment process? So let me turn that to you as a generic question. One thing you'd like to see either on changing administrative law or maybe changing administrative practice that you think could improve public input into rulemaking. Why don't we go in reverse order, if I could, as to what we started? So Amanda, can I put you on the spot for one closing comment?
Sure. I think that going back to what Beth Novick had said, that there needs, I think the key word there was concomitant, that there's the concomitant balance between creating this new system of online commenting and also having some way to filter through those comments to separate the wheat from the chaff. And I think we need to get back to that fundamental. And so I think increasing opportunities for people to comment through something like the Regulatory Accountability Act, with its notice of initiation of rulemaking, responsive comment periods, retrospective review, and then somehow combine that with, I think, greater technological innovation is probably going to be the answer to some of this. I think we've seen some companies who are already working on solutions to some of these problems. And so I think the legislature will have a place to play in this, but I think that greater technological innovation to address some of these problems will be part of the answer. Sorry. That was long.
Thanks. All right. Sabeel.
I think I would just add the point about capacity, right? I think to do this well and to do it in a way that then allows the government to solve public problems that need to be solved means you need resources, both for civil society and for agencies. And so, these are all great ideas, and we agencies need staff, they need resources, they need the ability to do this well. And I'll just pause there.
Good point. Nina, you had indicated and raised your hand when I mentioned Little Sisters. So if you want to comment on that, feel free. But very, very briefly, we're about a minute over our appointed ending time.
I'll just say very generally, and not on Little Sisters. I think one thing I've really learned from this discussion, which I've found so useful and generative, is that in some areas, we just simply don't actually have enough input yet. We don't have regulatory beneficiaries and communities weighing in when it could be useful in lots of regulatory initiatives. At the same time, we occasionally have these large volumes of comments coming in, which do create problems and do demand resources. And I was actually wondering if we might consider treating those in a different category. I put this in the comments of the panelists, kind of like the 100-year flood, where the agency has the opportunity to kind of pull a lever and say, we've got a big problem here. We need backup. We need backup to address these comments in a way that makes sense, filter the wheat from the chaff and the like. And so I think building capacity in both areas is critical.
Thank you very much. And Sally, last word.
Little Sisters is a very disturbing case. I won't go into it because we don't have time. I associate myself again with Sabeel. He talked about resources. There's also an awareness. I mean, civil servants in our regulatory agencies are there every 4 years. There's a prospect of new leadership moving in a new direction. And they feel like at some point, the political leadership is like the Christmas help. They'll go away and there'll be new people, and all they have to do is keep doing what they're doing. So agency awareness of the potential good from expanded public participation would go a long way towards changing the culture, which is essential, along with the money.
So I hope this conversation has conveyed a bit more than we've had a chance perhaps before to really dig into thinking about what the value is of public input. And I think, Sally, your point about baking that into the culture, to really value it, to really want to listen. It does take time, though, and I agree certainly with Sabeel's point as well, that when agencies are already taxed, it's easy to maybe just want to take a shortcut and go with what you've got the limited time and resources to do. But I hope that all of you who've attended this event have learned as much and gained as much from the insight from the panel members as I have. I want to thank Sally and Nina, Sabeel, and Amanda for your participation in this, and thank ACUS for organizing this session. And I will turn it over now to the next event. Danny?
Thank you, Carrie. Thank you all. Great. So I want to pass it off now to our distinguished speaker. We are pleased to welcome the Honorable Tino Cuellar to offer remarks on the role of public input in agency rulemaking. And Tino, Matt has given done a much better job than I can at your background and experience here. And I'm going to just pass it off to you.
Thank you, Danny. It's great to see you all today virtually. I'm incredibly delighted that ACUS invited me to do this. It's one of my favorite agencies, and it's really great to see so many people I recognize on this panel, and I admire Carrie, Sally, Nina, Sabeel, and many others. I have been now for several weeks in a different role than the one I was in for the last 7 years as head of the Carnegie Endowment for International Peace. So in my day job, I think more than I used to about US-China relations, about the Middle East, about nuclear weapons and security. But it made me so happy to get this invitation and to come back to my intellectual home. And as I think you'll see, the brief remarks I have today will highlight that all these issues are interconnected in some way. So let me go back and share with you an episode that is quite related to what we're discussing today and really reinforces the need for some intellectual humility. I started off my career working quite a bit on issues of public participation and rulemaking, and I wrote these articles about how we might rethink the process of getting input and what the data showed us about who was actually trying to participate in rulemaking. And I was pretty happy with some of these initial articles. And it's like so many of us who get a start in academia, we feel particularly enthusiastic when we get a chance to go to a conference, when other people are talking about these issues. And I remember maybe the second conference I went to on these issues, a fairly small gathering, but a couple of real extraordinary people were there that I admire. And one of them was the economist Roger Knoll, who's had a lot to say about regulation over the years. And he was the commentator on one of my papers on rulemaking and public input, and civic juries, and all that stuff. And he gets a chance to speak, and he says, well, you know, Tino wrote an interesting paper here. It's kind of interesting, the ideas he has, but you know what? Back in the 1970s, when the Carter administration was trying to rethink rulemaking, and there were all these DC Circuit cases involving public participation and limits of the APA, this was exactly the issue, and not much has changed. And that was like, I want to say like 2005. And I felt like that was such a letdown. I kept on waiting for him to say, and Cuellar's come up with a solution here, and it's all exciting and interesting, and what great ideas. But no, mostly he was sort of a bucket of cold water, and appropriately so. He said, like, there's some new interesting things here, but mostly we've been pretty much struggling with this question of how to get deep public engagement, but not in a way that paralyzes the process, pretty much since we became self-aware that rulemaking was a thing that required more than just technical scientific input. And that's pretty far into the history of rulemaking, if you think about it. So we're here again, and in some ways we are continuing the journey. And I want to take a few minutes to just kind of share what I think of as some important contextual factors and maybe a few implications from them that I hope you'll find both encouraging, but also maybe restating the challenge that we have. What I'm thinking about is first, how all that we talk about with respect to rulemaking around environment, around protections for worker health, around infrastructure, around, you know, electric power, around public health, all these things really implicate governance, and they implicate really problems and opportunities that are playing out really globally. We're talking about the great awareness the world has of interconnectedness around global health in the COVID era, the energy transition that's underway, even in countries that are not as concerned about climate change as perhaps they should be, and certainly in countries that are concerned, the dilemmas that those of us from Silicon Valley are constantly encountering around how the highly networked, increasingly autonomous computing infrastructure around us is to be governed and occasionally governs us. And then, you know, one thing we may not attend to quite as much as we might, and that's rising expectations of attaining or retaining a degree of prosperity among so many people in the world, billions of people living in places like Africa, South Asia, that, you know, a generation or two ago, many of these people may not have thought that it was plausible that they might live with something like a middle-class lifestyle. But billions expect that to this day now, and certainly in countries like the US and in Europe, many who had attained such lifestyles wonder about the feasibility of passing it on to their children. So that, plus these technological disruptions, the climate crisis, all that is part of our context. That complicates rulemaking, but it also highlights something that ought to give us pause about too much idealism that our generation of scholars, professionals will solve this problem of public input. And that is that if you look at any country bigger than Denmark, and maybe you could even include Denmark in that, I would say like no country at scale has figured out how to govern perfectly, how to deal with the pressures for change and continuity, how to avoid the most coercive and worst consequences if you're trying to put down, dissent, as happens in some countries. And if you're not trying to do that, how to take the mix of disagreement and idealism and cynicism and concern that defines so much of modern governance. That doesn't mean that everything is paralyzed or doesn't work, but it does mean that it's not easy to point to a country of, say, more than 40, 50 million people and say, oh, they've kind of figured this out. They've gotten it right. They know exactly how to balance all the competing demands. We have an incredibly rich and important constitutional tradition that gives us powerful resources like federalism, separation of powers, a set of agencies, and a set of expectations and norms of technical competence and input that are a really important resource in navigating all this, but it's not like we figured it out either. So with all this as backdrop, thinking of us as scholars of the administrative state and the world's largest democracy, all this is relevant to our work. And we might start to think about the relevance of these dynamics with a few premises, sensible premises that might help ground our discussion. And I'll mention three in particular. First, the ideal of public input is not just a vague aspiration in our system. It's actually part of a process for rendering regulatory decisions, certainly rulemaking, non-arbitrary. That affects how input happens, why it matters, why agencies take it seriously. And it means in some sense that society is forced to internalize the benefits and the costs of norms that we might have about public input. That is to say, if we come to think of it as standard that all agency rulemaking should have some complex process of digital deliberation, civic juries, and that becomes a norm that ends up being sort of a shibboleth of whether a decision is non-arbitrary, that is going to have benefits as well as costs. It also means that changes impacting the regulatory state can decrease certain forms of public input. Just to pick something out of the hat a little bit, a non-delegation doctrine on steroids might drastically reduce the extent to which agencies have the kind of discretion and play in the joints that ends up allowing them to have their decisions really informed in a meaningful way by public input. Second, having been around these issues as many of you have for many years, I almost want to start to say decades, which is kind of a scary thought. I think it's fair to say that we who think about these issues tend to be deeply conflicted about whether input from the public is mostly valuable as an instrumental resource for getting better decisions that protect public welfare better or more faithful to what is in the legislative provision that's relevant, or if we think of public input as sort of deeply valuable for its own reasons, as a marker of our commitment to a broader kind of participatory form of democracy. I feel that conflict. I don't think I've ever transcended that conflict. I think you can find some of that conflict in my own opinions from when I was a justice. And it's worth not assuming it away. I think that conflict is there for a reason. And I wouldn't want to live in a world where the only value of public input for our purposes is that at the margin, more lives will be saved. But I also would not want to fail to interrogate our methods for public input with the question like, how is this going to leave us better off? And I'll return to that at the end in about 45 seconds. Finally, I think that all the interesting technologies that we see that are now pretty standard around us, as well as developing virtual reality, video conferencing, AI-enabled comments that maybe reflect the subtle insights that members of the public might have but can't fully articulate, any of that stuff. I think that does give us some new interesting possibilities. But I think it would be pretty naive to the point of recklessness to think that any of those things are going to absolve us from, here in a democracy at least that takes itself seriously and tries to be intellectually honest, from core dilemmas about what we're really trying to do with public input. Like, what conception of the process do we have? Is it more technocratic? Do we just want to save more lives? Or civic deliberative? Do we want to improve the quality of deliberation, even if we end up taking more time, spending more resources, and ending up with a not as great rule from a purely efficiency perspective? And in particular, I think one of the ways in which these technological mechanisms for new forms of public input will not solve our problem. And here I'm going to channel my inner Sally Katzen a little, is, there's this deeper question of what relationship do we want to create between human and machine decision making? There are many answers to that question, but I don't think some straightforward use of any technology that's on the horizon right now is going to make that like a really simple, straightforward problem. So just to close, ultimately, I think the world will be well served by an American approach to public input and rulemaking that is innovative, that is not satisfied, that remains a little hungry, that is ambitious, but is also humble and aware of the trade-offs involved. And that means we got to take seriously that if we're going to strike a reasonable balance, we have to acknowledge that the goal is not only to get robust public input, but also to get sensible policies implemented. And we have to do that in a day that only has 24 hours, which I think makes it really tricky and means that the most thoughtful, subtle, effective policymakers in this area are going to be pretty tragic in their perspective. They won't be satisfied with what we have now. They'll look at just reams and reams of comments and feel like that's definitely not enough, but they want to get a rule done at some point and they want to make sure it saves lives.
Thank you. Thank you so much, Tino. I think we all strive to channel our inner Sally Katzens. So with that, we are going to switch to our next panel. Thank you so much.
My pleasure. Thank you so much.
So we're transitioning to our second panel now, which will be moderated by Kate Shaw, who is a professor of law at Cardozo Law School and co-director of the Florsheimmer Center for Constitutional Democracy. She is also a public member of ACUS. So we'll have a couple folks come in. I see Kate. Great. Hi, Kate. I'm going to pass it over to you to get started for the second panel.
Terrific. Okay, so thanks so much, Danny. And it was great to catch the end of Tino's remarks. I was unfortunately not able to hear the full presentation, but as Danny said, good afternoon, everyone. My name is Kate Shaw. I'm a professor at Cardozo Law School. I teach and write about constitutional law, administrative law, various topics in those areas, and I am a public member of ACUS. And it is a real pleasure to be moderating this panel today on specific ways agencies might enhance public participation in the rulemaking process, including things like new devices, new technologies, new tools. I am joined by a terrific panel with expertise that is both practical, so perspectives from inside agencies and active participants sort of from outside, but with the regulatory process, and also real scholarly expertise. So let me start by introducing our panelists, and then we will dive into the panel, which we are hoping to structure kind of more as a conversation than a series of presentations. So let me start with Reeve Bull, who's the research director of ACUS. He has worked on projects related to international regulatory cooperation, the use of science by administrative agencies, presidential review of agency rulemaking, cost-benefit analysis, government contractor ethics, e-rulemaking, among many, many other topics. He's also an elected member of the American Law Institute and sits on the council of the ABA's Administrative Law and Regulatory Practice section and serves as vice chair of that section's rulemaking committee. Next, I'll introduce Dr. Dwayne Goldman, who's the Senior Advisor for Racial Equity to the Secretary of Agriculture. He has served for the past year as Executive Director of the National Black Growers Council, the NBGC, a Washington, D.C.-based organization that advocates to improve the efficiency, productivity, and sustainability of Black row crop farmers. He's got more than 30 years of experience in the agricultural sector and was also a farmer in southeastern Arkansas. Before joining NGBC, he helped to form the organization and served as its initial advisor. I will next introduce Eduardo Martinez, who is an assistant professor of philosophy at the University of Cincinnati, where he studies democratic theory, touching on political representation, civic education, civic virtue, and the role of identity in democratic decision-making. He explores social and political philosophy informed by empirical research in the social sciences. And of particular interest to us, here today, he recently published the article, Realizing the Value of Public Input, Mini Public Consultation on Agency Rulemaking. And finally, I'll introduce Carrie Ann Jones, who is Senior Counsel at Democracy Forward. At Democracy Forward, she represents municipalities, nonprofits, and individuals in litigation involving all facets of the Administrative Procedure Act and related statutes. She's argued cases before the DC Circuit, the 8th Circuit, and worked on lots of motions and other practice in various US district courts. Okay, so that's our august panel. Let me make a few introductory remarks and then I will bring folks in. So we're not writing on a blank slate in this conversation, right? Again, I was only able to just join now, but a panel earlier today discussed different forms of public input in crafting agency rules, and a series of earlier panels that ACUS has convened over the course of the past month have tackled various dimensions of ways agencies can better engage with underserved communities in the regulatory process, just kind of broadly. And I don't want to be unduly duplicative, but I also don't want to assume that our whole audience here will have been able to join all of those earlier panels. So maybe before we dive into kind of what actual specific ways and what actual specific tools agencies might use to supplement their notice and comment processes, maybe we could ask, I could ask a couple of our panelists to basically give us a little bit of the general landscape. That is, maybe you could speak a bit to what communities are typically underrepresented in agency processes, maybe rulemaking processes in particular, since that's our topic today, why it is important for agencies to work to engage underrepresented communities in those processes. And so maybe, Dwayne, I can ask you to sort of start us off on that kind of broader framing question, and then I'll bring in others, and then we'll sort of shift to more kind of concrete discussion of tools and methods agencies might utilize.
Thank you, Kate. And hello, everyone. Interesting question. And I've spent a little time thinking about it. And I have to think back to a time when I was dependent on a certain decision to be made, but wasn't a part of the decision-making process. And that can be a frustrating experience. And we later found out that such experiences is that they actually have a cost. So discrimination, racism, bias, intended or unintended, they have cost. Studies have been done and shown a staggering cost over a 20-year period. Somewhere above $18-20 trillion would be the cost of not including everyone in processes that require everyone to be represented. More personally, I spent some time in our government affairs group when I was with Monsanto Company, and it was interesting to look at it from the perspective of those that have been left out of the decision-making process. And the common saying when you're talking about government affairs or advocacy or representing different groups, the common saying is that if you're not at the table, you're on the menu. And whether that's intentional or unintentional, if your views, your opinion, your experiences are not represented around the table when decisions are being made, oftentimes those people that are not there, and it may not be intentional, but the people that are not there are not represented. And so you end up with a larger and larger group of underrepresented interests and underrepresented people. And we have to think about that. How do you intentionally go out and solicit the input, and I would say the informed input from those that have been left out? And in a lot of cases, it can be difficult because if you've not been in on the discussions or on the development of the policy in the first place, the amendments to that policy don't mean as much. And so we really have to take a step back and look at, one, how can we bring people up to speed who've been left out of the process? And two, equally important is how can we factor that into changes, amendments that need to be made to existing policy to make them truly more inclusive?
That's a great start. Thank you so much. And maybe Eduardo, could I ask you to come in now and just, you've written about the kind of moral and epistemic value of public input and participation in agency processes. Can you talk us through sort of from your academic perspective, sort of what the values at stake are?
Yeah, thank you. Thank you so much to Kate for moderating this panel, and thank you to ACUS for the opportunity to participate. So yeah, the way I read some of the academic literature on the value of public input on agency rulemaking is you might think about some of the values being epistemic in nature, so having to do with information and knowledge, and some being moral, having to do with kind of moral values that we seek to instantiate in our decision-making processes. So on the epistemic side, you might think that public input helps us to advance the aggregation. So we can take lots of information that's distributed throughout society. Different people have different jobs, different experiences, different perspectives, and those all might help us to figure out what the likely effects are of a particular proposed rule, or figure out what the problems are that need to be solved. So aggregating can be epistemically useful. You also might think having lots of different perspectives bear on the decision-making process can help contribute to justification. So we can show how a rule is not just arbitrary, but is actually justified in light of lots of different perspectives of stakeholders that might be affected by it. On the moral side, you might also think there's a kind of robust right that's defended there, a kind of right to be heard, or expression of civic respect, that citizens aren't just subjects to be ruled, but also have a kind of respect as an interlocutor. Their input should be responded to in the rulemaking process. And last, we might think government more generally, policymaking more generally, should be accountable to citizens' interests. And so that public input might help policymakers, agency officials to understand the interests that are at stake and be able to respond to them, to advance them when they engage in rulemaking. And you might worry about some of the aspects of the status quo if they can't instantiate those, if you have differential responsiveness to proposed rules, differential impacts on who's able to take part in processes. They might not feel civically respected, their interests may not be represented, like Dwayne mentioned, and the information they have, which is very valuable, may not bear on the decision-making process.
So that's terrific. Maybe I'll segue now to you, Reeve, and just ask you to talk. Maybe we could you could bridge. We're talking obviously in kind of broad terms about goals and values here, and so I'd love to hear kind of your take on the value of public participation. And then maybe we could use you could use the remarks to pivot a little bit to kind of start to identify some of the challenges and limitations in the existing system, which you're obviously extremely familiar with.
Wonderful. Thank you, Kate. First of all, I'll just give sort of the obligatory disclaimer at the outset that I'm speaking in my own capacity. I'll draw upon ACUS recommendations. I'm not speaking on behalf of the conference or its members. So excellent question. And on the first point, I think I'd really like to associate myself with both Dwayne and Eduardo's remarks. I think that lays it out very, very nicely. I think if you look at the scholarship on the notice and comment process, generally there's sort of two overarching goals in theory that agencies are trying to achieve. One is to achieve a technically sophisticated rule, a rule that takes into account the dispersed information from members of the public that can be valuable in terms of ensuring that the agency is getting it right. And then many have argued that there's also a democratic aspect of the process as well, that it's a way for the agency to hear from members of the public and to achieve legitimacy that way. And I think that achieving broad and representative input is very, very valuable with respect to both of those aspects. With respect to the democratic aspect, I think it's obvious. I think certainly it goes to the legitimacy of the agency's processes. It also goes to ensuring that, if the agency is trying to sort of channel public opinion in some way, then it should ensure that it's getting an accurate picture of public opinion. And the only way of achieving that is to ensure that it's getting a representative set of inputs. But I think it's also, and I think both Dwayne and Eduardo touched on this, is quite relevant on the technical side as well. On our first panel, for instance, I think it was Nina Mendelsohn who gave the example of a rule where the agency was proposing tripling the fees for national park admission. And the agency got a very, very negative reaction to that. And, so that's actually relevant to sort of how the rule is going to be, implemented, whether or not people will support the rule. And so it can be technically relevant on that front as well as to sort of how the rule will operate in practice. Pivoting then to sort of, how the current system serves those goals. I think that, and we can get into more detail sort of later as to sort of some possible supplements, but at the moment, I think it's fair to say that notice and comment is really the preeminent mechanism for receiving input from the public. There are a handful of supplements that currently exist that we can discuss, as well as possible supplements we might discuss. But in the vast majority of rules, notice and comment is really, if there's any mechanism for soliciting public input, depending on whether or not it qualifies for an exception, notice and comment will really be the exclusive mechanism that the agency is using. And I think the first panel touched on some interesting points there as well. In many rules, the agency doesn't get any comments, and probably most rules, they get a relatively small number of comments. I think Carrie, Colleen, and AC pointed to 12 as the median number of comments that agencies receive. But in a handful, and it's a very, very small percentage, but in a handful of rules, agencies get a massive number of comments, hundreds of thousands of comments, millions of comments. And I think there are concerns on both aspects, that we've discussed, both technocratically and democratically, as to whether or not the notice and comment process is sort of really achieving these two goals. So on the technocratic front, as we saw in the first panel, and as I think both Dwayne and Eduardo alluded to, you tend to get the same people, involved in the process. It's usually well-connected, whether, industry or NGOs, the same participants usually, show up in the majority of rules that get a small number of comments. Whereas in these large rules that produce a massive response, obviously you're getting a much larger number of inputs from a much larger number of people. But there are some real concerns as to how representative it is. The FCC net neutrality rulemaking is a good example. There were something like 24 million comments received, but a huge number of them were from bots, from computers that were actually generating comments, or mass comment campaigns, which may not necessarily be representative of the general public. So I think if you look at the existing system, I think probably in most cases it does a reasonable job on the technocratic front in terms of getting technical input, but it could almost certainly be improved. And then with respect to these mass response rules, I think there are some major concerns as to whether or not the input that the agency was receiving is representative and is ensuring that all interested parties do have an opportunity to weigh in. So let me stop there.
Okay, that's great. And there's obviously lots to follow up on in what you said, Reeve, but maybe Carrie Ann, let me bring you in here. And I do think we'll talk about ways to address, sort of low and excessively high in the mass comment sort of domain levels of participation, and then, questions both of, I think, technocratic and democratic, goals and shortfalls. But maybe, in terms of, so we've referenced sort of the usual suspects who participate in a lot of rulemaking processes. From your vantage point, having represented, interested parties, right, seeking to, file sometimes long comments in response to proposed rules, sort of what do you see? What voices are represented, underrepresented, sort of what distortions and kind of distributional effects have you seen in your work with respect to agency notice and comment processes?
Yeah, so it's a good question. So I think, you definitely, some of the kinds of voices that are being underrepresented include, individuals who are receiving benefits when agencies are trying to change, aspects of the benefit programs. You don't see legal aid societies or legal aid organizations getting involved. I think there's a real gap in sort of the workers' rights and criminal justice spaces. And academics, actually, I think there's a real gap in terms of agencies hearing from subject matter experts. And, I think there are a lot of reasons for this, and some of them I'm sure we'll talk about more, but I think part of the issue is that, agencies need to be doing a better job at reaching people where they are. Not everyone in the United States is necessarily reading the Federal Register every day. And so a lot of times, in my work, I'll reach out to a constituency or an organization that I think would have really good data and really good information to provide to an agency in a rulemaking, and they've never heard of the opportunity, or they heard that it was coming, but they hadn't actually realized that the rule had come out, or whatever the case might be. So I think, trying to figure out a way to better communicate to the public, thinking a little bit more broadly about what kinds of comments would be useful and who might have that important information, will be helpful for agencies as they think about how to do these outreach campaigns, in order to get some of these voices who just aren't, as Reeve said, it's the people who are connected, who have established regulatory, practices, who know how to write these big substantive comments, but they're not always the people who have the most relevant data, or at least not all of the relevant data that could be useful.
Okay, so maybe I'll pivot to you, Dwayne, on that point. So could you talk a little bit about, from your vantage point in agriculture, sort of what sort of public and stakeholder outreach and engagement is ongoing, just in terms of, again, kind of getting the current landscape?
Thank you. And I want to start by reiterating Carrie Ann's comment about reaching people where they are. When I take that comment in light of the earlier comment that I made about people not being represented before, that becomes even more important, because if we keep doing things the same way, we're going to keep reaching the same audience. So we have to look at where people are. Otherwise, you find yourself kind of preaching to the choir, and the people that need the message most are not getting it, or not able to input the process. But you asked me about things that are going on at USDA, and it's a good example. I mean, if you look at one of the pivotal mandates of the Biden-Harris administration, it was to have the country take a deep and serious look at racial justice and equity. So much so that an executive order was signed essentially on day one, where the president gave his cabinet level appointees, one of which is my boss, a little bit of latitude as to how they accomplish that objective. And the position that I serve in is a new position, Senior Advisor for Racial Justice and Equity. It's a new position. And so we're challenged to do exactly what you talked about. How do we engage folks that we need to engage with to make sure that our programs, our services are more just and equitable? And so if we focus on those that have benefited from our services the most, you're going to just perpetuate the discrepancy. So what we've done, and I'll say as a farmer, as a practitioner, and later in my career as kind of an advocate, I've gotten a little more comfortable speaking up for the needs of those that really were not represented. But now I see the whole department really assisting in that effort to reach people kind of where they are. So it's not that we go out to the usual list of folks that are there in the larger meetings, or folks that are well connected and are looking at the internet and getting updates. But where are those, how do you access those people that have been left out of the process? And there's a number of things that we've engaged in, and this is a work in progress. So, we have a pretty good database of the farmers that we are obligated to serve: farmers, ranchers, landowners, et cetera, rural America. We have a pretty good database. And if you look at our stats, at our statistics from the National Ag Statistics Service, there's some indicators in there that says that USDA, perhaps you need to be more intentional about how you reach some of these audiences. In addition to that, another complicating factor is, because our services have not reached them equitably, guess what? They're not very familiar with us. They don't really trust us. And they have not been able to connect the dot from a piece of legislation or policy being developed to a tangible benefit on their operation. So what we're doing is going to those people that are a little bit disgruntled sometimes, but we're talking about the programs, we're talking about the discrepancies, and we are soliciting input from them on how we improve this process. And that looks a little different depending on what part of the country. And so in some cases, we are directly reaching out. We have a lot of community-based organizations. And these community-based organizations are oftentimes tied to universities, and particularly some of our minority serving institutions that have actually better relationships with our customers. So we are working through them to build a kind of rapport that would give those customers a little bit more of a comfort level in telling us how our programs don't work. And we have to do that in full view. We also have to weigh that against the folks that we're continuing to serve, because this is not about pitting one group against the other as much as it is about improving services to all of our customers. So we need to continue to do good servicing for the people that it's worked for, but have listening sessions that will hopefully get those underserved customers to a level of candor that allows them to share with us some pretty detailed information about how it doesn't work. And I need to tell you, we need to be humble in listening, because all of the information that we gather is not necessarily pleasant information, but it is the reality. And if there's a disparity there, there's a discrepancy there, we have to address the discrepancies and disparities in a realistic way. And so, but reaching out to those customers, relying on third-party people that have better relationships, and doing what I would call real listening sessions. A lot of times we take a listening session as an opportunity to tell our customers the options we have, the programs we have, and how they are supposed to work. But the flip side of that is really closing that one mouth you have and opening those two ears to hear from them as to how those programs actually work on their operations. And that's the part that can be, one, pretty informative, but two, pretty humbling at the same time.
Can I ask a quick follow-up question, Dwayne? So you referenced Executive Order 13985, the Advancing Racial Equity and support for underserved communities throughout the federal government, and at discretion sort of at each agency in terms of how to implement. So you mentioned that your position was created pursuant to that executive order. So it's very helpful to hear. Are the kind of listening sessions and sort of work with community-based organizations, and also to kind of work directly with some both growers and customers, it sounds like, and maybe you're using those terms interchangeably, I wasn't totally sure. Is that all relatively new work and work that has been sort of stood up pursuant to this new executive order?
It's not new, Kate. That's a good question. It's not new necessarily, but I think what we're trying to do is take a new approach. So the listening sessions, and I've, every year I had the pleasure of serving 3 terms on an advisory committee for minority farmers. And in that process, we had very public-facing listening sessions. And people come there with legitimate complaints. And after a while, you get to a point where I've heard this before, but to a customer who's never had access to a committee or a group, you've heard it before, but you haven't heard it from them. And so when you're in the position to take those recommendations or criticisms and convert that to a better delivery, you find yourself in the position of trying to kind of consolidate and develop policy that can address the multiple concerns from people, because at the core, a lot of them tend to be fairly related. Poor customer service, complexity of programs and the like, distrust. When you look at the core causes of some of those criticisms and focus on policies that can overcome that, it allows you to kind of bracket things that can result in improvements, but it all ties back to, and I know in this discussion we're talking about rulemaking, but it all comes back to rulemaking and how can we take that input and develop and write rules that are more inclusive.
Great, and that's a great pivot. So maybe, yeah, so let's shift sort of to think a little bit maybe more specifically about the rulemaking process. And Reeve, do you want to talk a little bit, we've sort of laid the groundwork, and you've written about, a number of kind of specific proposals for democratizing and technocratizing the notice and comment process. I invite you to, maybe identify a few and sort of talk through both the problems being addressed and the solutions that you have offered up, and then maybe I'll bring in Eduardo and Carrie Ann.
Wonderful. Yeah, thanks, Kate. Excellent question. So, yeah, I can sort of maybe give a quick preview of sort of, some of the things, sort of the framework, in which I've tried to lay it out and sort of some of the ideas that I put forward. And then, agencies have also in some instances actually put in place. So yeah, you're exactly right. It's sort of, to me, the way I look at it is sort of how do you enhance both the technical input that the agencies are getting as well as the democratic input that the agencies are getting, all while being mindful of the fact, and this is something, we at ACUS hear from the agencies all the time, that this takes resources, it takes time, it takes money, it takes agency staff time. And, for every additional mechanism that the agency puts in place, in a zero-sum world, that's something that they may not, otherwise be able to spend their time on. So I think, to me, that's why sort of the most important question to ask at the outset is sort of, what is the agency trying to achieve with a particular rule? And for some of them, if it's highly technical, if it's something that as a pure question of scientific knowledge or something like that, obviously they're still going to go through the notice and comment process. But to the extent that they're looking to supplement the notice and comment process, they may want to focus on things that are really much more focused or more geared to get that sort of technical input. So for instance, Dwayne mentioned advisory committees is one possibility. The agency under the Federal Advisory Committee Act can convene an advisory committee of technical experts, and they can then get that, that technical information. And another possibility that's sort of, still at its infancy, but agencies have increasingly looked at potentially the use of AI, artificial intelligence, to either deploy it on their own or as stakeholders might use, algorithms to produce, identify relevant information that they can then submit to the agency. That may enhance the agency's ability to get technical information to help it make the rule as sophisticated as possible. On the democratic front, again, it's going to vary a lot depending on the rule, but for some rules, it may actually be very, very relevant, how the public might react to the particular rule, or what course of action people think that the agency should be undertaking. As we all know, that's how most people perceive the notice and comment process. When you get these mass comment responses, the vast, vast majority of them are saying something either to the effect of I support this rule or I don't support this rule, or simply offering their own personal reactions to the rule as opposed to saying, providing technical information or even saying this rule would affect me in the following ways. Oftentimes it's just a mere expression of opinion. And it can be debated as to the extent to which agencies should, take just pure opinion into account. But if they do, then I think it's critically important that they ensure that they're getting a representative view from the public. And the notice and comment process, frankly, is not a good way of achieving that. It's wildly unrepresentative. So as a consequence, a few of the things I've looked at that might supplement notice and comment, you could do an opinion poll potentially. Of course, there are legal issues associated with that. Possibly the Paperwork Reduction Act may constrain the agency's ability just to do a pure opinion poll. Another thing that I've spent some time writing on is a citizen advisory committee, where the agency actually gets a demographically representative group of people, like provide them briefing materials, and then they, debate the issues and actually come up with some recommendation to the agency that the agency doesn't have to take into account or doesn't have to follow necessarily. But the agency, might want to consider that if they want to get a sense of how the public, a demographically representative group of the public would react to a particular proposal. And then there are things that are much more basic that would just be sort of supplements to notice and comment, trying to use, social media or other innovative methods, perhaps instead of requiring somebody to file a full comment, you could have people like comments or dislike comments, make it easier to sort of meet people where they are, and sort of simplify the process in a way that hopefully would lead to a broader and more extensive set of participants in the process. So those are some of the ideas, I put forward. I'm sure there are plenty of others, but I think, there are a variety of different ways agencies can supplement the process, but I think it's critical that they sort of first ask, what are we trying to achieve? and then tailor the method accordingly.
Yeah, I want to underscore those are all really interesting, and there's, I think, lots to follow up on. So we'll have some opportunity for crosstalk momentarily. But maybe Eduardo, maybe I could bring you in, because you've also, so Reeve has laid out in various writings a number of these proposals, the citizen advisory committees, that I think the public opinion poll is such an interesting proposal. I gather, because you're worried about the Paperwork Reduction Act, there would need to be a statutory fix in order to clearly establish the legal authority for agencies to conduct such polls. But to the extent that there's like comments are sort of weighed in like a plebiscite type fashion, it's a terrible way to actually gauge public opinion. I think you've made that point very effectively, but that doesn't mean that agencies should just abandon the effort to essentially gauge public opinion in these processes. And I do think that thinking creatively about better ways to actually elicit genuinely representative views from the public is a really important project. But yeah, so Eduardo, do you want to jump in and talk about some of the proposals that you've offered?
Yeah, thanks. So yeah, I think building on Dwayne's emphasis on the depth of engagement and Reeve's helpful kind of laying out different opportunities, I'm also worried about the lack of representativeness in the notice and comment process. And I think in democratic theory, often there's a concern with not just looking at mere public opinion, but thinking about public opinion, public reasoning under particular, perhaps especially healthy conditions. So some democratic theorists have often been interested in something along the lines of what Reeve talked about with the citizen advisory panel, but what's sometimes called mini publics. So it's groups of citizens, often representative sample, coming together, like Reeve mentioned, looking at briefing materials, but you're often focused not just on kind of snap judgments or what public opinion currently would be for especially salient issues, but taking the time to discuss with people with different perspectives, sometimes talking to experts and seeing what the results, either looking for consensus, looking for reported different perspectives, or even polling the group before and after to see how those perspectives change and look at the particular reasons that are given and not just the kind of up or down vote that you might get from certain kind of mass comments or from a plebiscite. And I'm particularly optimistic about that as a supplement to the notice and comment process. I also think it might even substitute in some cases for when you have salient issues that get lots and lots of mass comments, because they're not especially conducive to the kinds of engagement of reasoning and justification that seem especially both epistemically and morally valuable, that you can't just get that from a straight judgment about whether you support a rule. So these cases might supplement getting a more representative sample for rules that aren't getting a lot of public salience. And then in cases where they are especially publicly salient, perhaps are more manageable and more in-depth form of engagement with public input that perhaps better represents citizens' interests rather than just a straight initial response from public opinion poll.
And Carrie, I want to bring you in, and I'm not sure if you, based on your sort of work with agencies and with clients, if you have reactions as to sort of whether in your experience agencies are, if you've worked with agencies that have tried any of these supplemental or sort of methods of supplementing ordinary notice and comment processes, or if you also sort of have ideas. It sounds like you have yourself sort of gone out and generated public engagement, but from the agency end, sort of what other tools or mechanisms agencies should be using.
Yeah, so I mean, I think everything that Reeve and Eduardo said make a lot of sense to me. I think are great ideas. I think, first and foremost, GSA needs to fix regulations.gov. As some of you may know, Democracy Forward's filed a comment on that issue. And right now that's, the main way that you are, and sometimes the only way that you can submit a comment on a proposed rule. And it is just incredibly inaccessible and unintuitive. You can't search by docket number, you can't search by the name of the rule sometimes. So, I just think, just really getting down to brass tacks, I think all of these ideas are really great, but also we need to fix the tools that currently do exist to get public input. And so one of the ways to do that is through fixing the regulations.gov website. But I also really wanted to sort of build on what Reeve was saying about just making it easier for people to comment. I think a lot of times there are organizations, and again, I'll go back to like legal aid organizations that could have really beneficial information about how a change to a program is going to affect communities. But they are resource strapped. They don't necessarily have the ability to file these big comments. So thinking creatively about ways that agencies can, through the notice and comment process, reach out to those organizations and say, look, you don't have to give me a 20-page comment, just, answer these questions. Here's a survey here, how many clients have you had that have experienced this problem, making really targeted questions so that you're not asking, so that the burden is lowered, is lessened, and therefore you're able to get more people involved.
Really helpful. And I know I have to confess, Karen, I know you guys submitted like a 70-page or something comment about regulations.gov. And I'd actually be curious to hear more because I did not have a chance to make it all the way through. And I'm sure that folks in the audience haven't either. Just like what specific, it seems like this should be fixable, like this should be doable. And so sort of can you talk a little bit more about the problems and the sort of potential and the solutions that you identify? Because this has to be the one of the very first steps, it seems like.
Right. And I think it really is fixable. I mean, so what we talk about that in the letter is that, the agency really needs to go back into regulations.gov and redesign it with a user experience in mind. A lot of the changes, and these changes were happened when the website was sort of updated. There was a new version that came out in the last year or so. And a lot of functionality just went away with that. So you can no longer mass download or bulk download comments. You can't see where you used to be able to do that. It's harder to find the comments. The comments aren't, they aren't where you think they would be. You can't necessarily go through and search the potentially hundreds of thousands of comments by, the author, or sometimes the agencies use title and author differently. So it's hard to figure out, which are the comments you're really looking for. Again, docket numbers, you can't search by docket numbers. So if you, see something in the Federal Register and you try to go find the docket for it, because of the way that the search allows for or doesn't allow for use of special characters, because you can't search with partial docket numbers, and sometimes it's all you get from the Federal Register, it just makes it very hard to find these things. So those are just some examples of ways that the functionality and the use of regulations.gov has just gotten significantly worse with this new version. And I completely agree with you. I think it's something that has to be step one. Like, we have to fix the tool we have, as well as think about all these other amazing ideas for engaging the public.
So I want to mention now that we'll take, happy to take questions if people want to start populating the Q&A now, and then we can just get to them as we get to them. But I meant to say that earlier, and so I will say it now to folks tuning in. So maybe mass comments we've sort of now referenced a few times, and it seems, as Reeve, your opening remarks, we have a very low participation problem, or maybe it's not a problem, maybe it's appropriate, but a low participation level, sometimes a problem. Certainly, the underrepresentation of voices and groups is a problem. But then we have this small subset of rules that does generate, right? You of course mentioned the very famous example, the FCC, both net neutrality rule and then rescission, as generating millions of these mass comments. And that's obviously something that you have worked on both with your ACUS hat on and without your ACUS hat on. So I don't want to, I'm not trying to put the ACUS hat on you, but I think it's obviously an important dimension of the discussion of reforming agency notice and comment processes. So do you want to talk a little bit sort of at more length about kind of the problem and some potential solutions that you've kind of thought about and written about, Reeve?
Absolutely. So yeah, and to sort of briefly, describe our findings in that report that led to ACUS recommendation 2021-1. So, we surveyed a pretty extensive number of agencies and also spoke with stakeholders and people who participate in the notice and comment process. And the overall take on the agency's part was, at least with respect to the mass comment issue, that first, as you noted, Kate, it's very, very rare that agencies will get a mass comment response. You're talking about it less than 1% as a general matter. The rules that they issue in any given year receive thousands of comments. And certainly, these outliers like net neutrality, where you have millions of comments, are exceedingly rare. And the agency's reaction, at least for the time being, was it's not that big of a problem because the agencies do, in fact, have now software that allows them to go in and analyze the docket, and it actually tells them if they get comments that are identical or nearly identical to each other, which is very common in these mass comment cases where public interest group or an individual will encourage people to submit exactly the same text or very identical text to the agency. These programs can go in and basically say, okay, this comment is 100% identical, or it's 95% identical, and it makes it a whole lot easier to process. So, even if the agency is getting hundreds of thousands of comments, oftentimes 80–90% of them are identical, and therefore they can just sort of screen those out. So at least with respect to where we currently stand, it's not necessarily that big of an issue, at least in terms of the processing of the comments. Where it is a larger issue, I think, is sort of what we've been discussing, which is that not only do we have these concerns about representativeness generally, but I think this sort of exacerbates the concerns in the case of these mass comment rules, because you would have every reason to believe that the comments you're getting are not representative, that it's actually some entity that's encouraging, individual people to file thousands or, hundreds of thousands of iterative comments saying the same thing. So that's one potential concern. The other concern that's really, I think, further sort of, underscores the potential legitimacy problem is that anymore, the comments are not always generated by actual human beings. It's become very common that people write algorithms that in some cases just generate comments and submit them anonymously to agencies. Or more troublingly still, in some cases, these algorithms will generate comments and then they'll misappropriate identities. They'll actually go on the internet and find people's names and say the comment is coming from somebody who's not in fact submitting that comment. And the New York Attorney General did an extensive study of the repeal of net neutrality that showed millions of the comments received actually fell into that bucket. They were generated by an algorithm, and in some cases, people's identities were misappropriated. So at least at present, that's sort of the major concern in the mass comment space, is that the comments are not representative. They may not necessarily even correspond to individual people. And they give the agency, perhaps a skewed picture of what public opinion actually is. Of course, moving forward, I think it becomes an even bigger problem because in most cases, from what we understood from the agencies, at least in the past, when a bot generated a comment, it was usually pretty obvious that it was a bot comment. The syntax was off and, it was fairly clear the human didn't generate it. But increasingly, these algorithms have become sophisticated enough that at least in a handful of cases, the bot generated comments are indistinguishable from human generated comments. And without additional investigation, the agency may in fact think that it's an actual person that's filing the comment. So at least at present, I think those are the main issues that agencies are grappling with in the mass comment space.
Dwayne, can I bring you back in on, so, your opening or maybe the second answer that you gave was really, just gave a very textured sort of picture of the active way that USDA is looking to do outreach and engagement. In terms of the notice and comment process specifically, you said it does sort of tie back to notice and comment. I wondered if I could get you to sort of to say more about how, it sounds like these are dialogues, right? They're listening sessions, but they're also talking sessions. And so you're educating about programs and also taking sometimes critical feedback about programs. Is that also happening in conjunction with actual open rulemakings, or can you just talk about sort of notice and comment kind of process at USDA and how, if at all, kind of implementation of the equity executive order is specifically happening, or there might be future plans for that to kind of happen with respect to notice and comment processes?
Sure. Let me kind of frame this up, and I'll try and be brief. In the executive order that President Biden signed, it mentioned an equity commission, and this equity commission would be expected to provide the kind of pertinent information and recommendations that could get us in a better position. I started March 1, okay, in this current position. And so immediately, and there was already work underway, but when I started, we immediately started looking at kind of a cross-departmental effort as to where we were from a racial justice and equity standpoint. A critical part of that was in late July, we engaged in some listening sessions, if you will, those listening sessions we talked about. But in order to do that, we had to do an RFI, request for information. So we were really using that information to formulate how we would do these listening sessions. And all of this is building up to information that we could share with the Equity Commission to get us to a better point. but I was not experienced in that process. So the RFI, the request for information, was pretty eye-opening for me because it announced to the general public that this is the kind of information we're looking for, and this is our intended use of this information. So we engage with over probably close to 1,000 people, farmers, ranchers, rural community people. But by having signal the intent of what we were doing, I think it helped the customers prepare for information that they wanted to share with us. And as you can imagine, when you're doing a listening session, a few comments are, yeah, you're doing a great job, keep it up, etc. That's not the majority. The majority of comments are dealing with frustrations and omissions and gaps that need to be addressed. And so, but by going through that process, it really opened my eyes up to, and we're talking about notification, it really opened my eyes up to the importance of this full process of, announcing the opportunity, preparing the folks we're trying to help, preparing them to provide us information that can help us in this journey. We're still synthesizing some of that information. Hopefully we'll have that done, by the end of the year, but we're still synthesizing some of the information, trying to really figure out how we can take this and convert it, transition it into active rules, regulations that can help us. But that process has been fairly interesting. And I think the other thing that it did, we heard a lot of comments that we've engaged in these kinds of exercises before. But the difference this time was because you have kind of laid out a spectrum of things that will happen with this information, I think they're giving us an opportunity, they're giving the department an opportunity to kind of restart. I'll share with you some information. I'll give you an opportunity to process, use that information for improvements. And the important part is, I expect that they're going to hold us accountable because, as they should, because, that was part of the deal in the first place, was to get information, hold us accountable, work with us as we develop solutions.
Maybe I'll pose a general question about the kind of role, the role of law here. So just like, are there either legal constraints or, legal, so the executive order that Dwayne, we referenced a couple of times, seems like it has set in motion a meaningful process that actually, could increase, engagement and participation, at least, at this agency. And obviously there are parallel processes playing out in other agencies. I'm curious, and I'm not sure, this is kind of an open-ended question, so anybody should feel free to jump in, but, thinking about trying to, just sort of obviously there are kind of, there's a legal framework within which agencies operate. Certainly notice and comment is a floor. Notice and comment has its own sort of, legal requirements attached to it, right? Agencies have to, right? There's a body of law that says agencies have to not only, provide an opportunity for public participation, but consider comments. Not totally clear sort of how, all that sort of the specific legal requirements are. But I guess, anyway, I'll throw open a somewhat inchoate, or throw out a somewhat inchoate question about whether the law, and again, the executive order is now out there sort of with a different kind of legal directive there, but whether the law constrains or should be reconsidered in terms of what it requires of agencies and whether there are limits it places on agencies kind of in their ability to actually kind of generate the optimal level of public and broadly representative public participation in rulemaking processes or regulatory processes kind of more broadly. I'll call on someone if I have to, but I thought I might just be a little bit more open-ended.
Well, let me jump in first before the experts weigh in. And I should have said, Kate, if I don't mention the Office of General Counsel and the importance of doing this within the prescribed rules and regulations, I'll get my hand slapped. And so that's an important part of this process. But if we look closely at the executive order, let's take a step back to my earlier comment about being on the outside and not being in the room when the rules and regulations are made. And so in my interpretation of the executive order is it requires us to do this legally, but it also requires us to identify those things that might require a change in the rule, or in this case, or a change in the law. Because if the law was written not fully considering everyone that it should have served, then we have to consider the fact that the law itself could be flawed, and that has to be part of this process. Now, the other side of that is, if the law is flawed and does not allow USDA in this case to make the needed change, the first thing we've got to do is, we don't have the latitude of breaking the law. We do have the responsibility to inform those who make the laws that this law is fundamentally flawed and needs to be changed. And I think that has to be part of this process.
I'm also happy to weigh in. I think those are all fantastic points. And yeah, I think there's sort of two, I guess, key legal considerations here. And I think that to some extent, the law is relatively sparse, in this area. And I think that sort of partly explains these phenomena that we're seeing. So sort of the first question is, what do agencies have to do? What are they legally required to do as far as public input is concerned? And in the vast majority of cases, notice and comment is the only legal requirement. That unless an exception is satisfied, then the agency has to go through the notice and comment process. There are a handful of instances where that's supplemented. So the one that's immediately coming to my mind is SBREFA, that requires agencies, a handful of agencies, EPA, OSHA, and the CFPB, to obtain early public input before they actually do issue a notice of proposed rulemaking. The executive order that Dwayne mentioned obviously imposes additional requirements on agencies. And then there are a handful of other statutes and executive orders, in some instances might require some sort of supplement to the notice and comment process. But as a general matter, those are relatively rare. In most cases, the vast majority of cases, the agencies will be able to satisfy their obligation just by going through the notice and comment process. Then I think the second question is, then what are the agencies required to do with the input that they receive? And I think that one's even less clear still. I mean, the standard that's been articulated in the case law, Kate, as you had mentioned, or actually the statute 553C requires that agencies consider the relevant matter presented in the comments, and then the agencies are required to respond to significant comments that they receive. And I think to some extent, this sort of explains sort of the incentive problem here, because sort of the more input that the agencies get, then the more that they have to respond to as part of this process. So to some extent, it doesn't necessarily benefit them to sort of, go beyond, the floor that the law has created. And I think that's probably the key challenge here, is sort of trying to create an incentive structure such that the agencies find it beneficial to actually go out and solicit this additional input and then make appropriate consideration of it. And I think there's a real tension between, on the one hand, giving the agencies the flexibility they need in order to design the process in a way that makes it useful. And then on the other hand, ensuring that the agencies have the proper incentives in place to, engage in this type of supplemental outreach that could be valuable.
Carrie and Eduardo, I'm happy to take anything from either of you. I mean, I guess, if you don't have anything sort of immediately springing to mind, a follow-up question is, right, so that was a great response and very much kind of anticipated this question. Well, if there is this incentive problem, like, that there are, maybe good governance and moral, and now through this executive order, like, actual, legal reasons to actually solicit broad input. But there is this kind of counterforce, which is resources are limited, and sort of more comments require responding to more comments. And maybe there is no sort of easy legal fix that would better align incentives in the way that you are describing. But I don't know if there are, if we think that there is, if additional executive, additional either White House directive guidance, additional executive order, I'm not sure I mean, you know, I'm not sure that I fix the APA is required here, but I guess I don't know whether we think there is a way that if law is in some ways working at, or some legal obligations are working at some cross purposes to kind of broader participatory moves by agencies, whether we should consider, you know, legal fixes or additional hard law to respond, or whether this is actually something where sort of less law is better. It gives agencies kind of more flexibility and the ability to kind of be dynamic and responsive. And it's just about, you know, creating the right processes at the agency level rather than enshrining much of this in additional kind of hard law.
So I think that frames it perfectly. And, you know, I think it's a very challenging question. And I think it varies from case to case, you know, like I could certainly see, and again, I'm speaking on my own part here rather than ACUS, but, you know, I could certainly see instances where, and there have been bills that have been, you know, considered that maybe in some cases would say require something like an ANPRM, you know, before the agency actually gets to, you know, formulating a rule. They would actually have to issue a pre-notice of proposed rulemaking document and obtain the public input. And I think in many cases that could be quite valuable because, you know, when the agency has actually reached an NPRM, it's often decided, you know, what course of action it wants to take. And so getting the input upstream while the agency is still considering how it might want to act or how it might want to proceed, I think could be very, very valuable in terms of shaping those rules. So it's certainly in certain instances, I think it might make sense actually to have a requirement in place, you know, whether it be statutory or whether the agency itself might want to, as part of its regulatory corpus, provide that in certain types of rules, you know, they will pre-commit to, you know, engaging in, you know, early outreach or a particular type of outreach. But then in other cases, you know, that may overly proceduralize the process. It may be excessive and it may simply slow the process down, such that the agency is pre-committing to do something where, you know, the benefits may not necessarily outweigh the costs. So I think it has to be very case specific, very agency specific, and then very program specific within the individual agencies. But at least for my part, I think at least in certain instances, there might be some value in pre-committing, at least in terms of certain types of rules, to engage in certain types of supplemental outreach that could actually, you know, greatly improve the quality of the rules that agencies are producing.
Yeah, Eduardo, please go ahead if you've got some.
Yeah, just to follow up, I think Reeve helpfully laid out that the trade-off is complex. I'm not sure I have an all things considered answer, but I wanted to stress the point that he made about the incentive agencies have to, when they get to the notice, already kind of feel like they have a rule pretty close to final form, and it's a lot harder to change. And that, I think, connects to some of the issues we started the discussion with, that amplifies some of the differential responsiveness toward regulated entities and groups that have the resources and expertise to contribute you know, well-resourced, well laid out, researched comments. And so they're going to have a greater say in the process. So if we want to respond to this concern about a lack of representativeness or unrepresented voices in rulemaking, we also might need to think about input before we even get to the proposal stage, before the notice of comment process. And another reason to think that that's important is just citizens, stakeholders are really creative. And that's something that's really valuable. It's one of the reasons that democracy can be valuable. We want to be able to harness that creativity, and agencies have lots of expertise stored in them, but it's also not always obvious which stakeholders are going to have something important to say about a particular rule. One kind of illustrative example I can think of is in some Cornell research on experimental online tools. They were looking at, I believe, a DOT proposed rule about runway procedures. And to their surprise, they found a lot of stakeholders with food allergies had a lot to say about a proposed rule. That may not have been obvious to transportation experts, civil engineers, those working in aviation, but it's something that was really helpful to thinking about the final product, and also might be something that those individuals have thoughts on how to solve the issue at stake. And so harnessing that creativity, that dispersed information, can be really valuable well before we even get to the notice and comment process.
Carrie Ann, do you want to jump in here? I mean, just in terms of if we were to shift, and I think Reeve, I take the point that this is, you know, this is not something that we would want necessarily to mandate in an across the board way, but that agencies would be well served in some instances by soliciting actively, you know, input and participation prior to actually crafting a proposed rule. Reactions to that, and also, you know, overcoming, you know, how I guess, like, thoughts or ideas, not to put you on the spot, but sort of how agencies can do a better job of actually reaching out to kind of the right stakeholders in order to elicit the kinds of, you know, creative, interesting, important solutions that Eduardo just identified.
Yeah, well, I think I agree with Reeve and Eduardo that I think definitely there are times when getting that input before a proposed rule makes a lot of sense. The agency can't deviate too much from the proposal, or it has to open notice and comment again. So the incentives are off to do a lot of changing at that point. So I totally agree with all of those points. In terms of how to reach the right communities, I think it's a lot of the things Dwayne's talked about and Reeves talked about, and Eduardo, thinking about citizen advisory committees or just more advisory committees in general. Thinking about, listening sessions, engaging with community organizations, making sure that you're cross-posting, opportunities for comment in multiple places and posting them in places where people actually go to look and to see, in whether it's blogs or whatever the case might be on social media, I don't know. So just really trying to be better at communicating to the various constituencies. And then also I think, and I really liked Dwayne's point about this earlier. I think trying to give folks a sense in some way that their information is valuable and is going to be used to do something good, or that is going to be constructive, that it's not just going to be ignored. I think that trying to figure out a way to set that stage is a really important part of making sure that people feel empowered and feel like they want to make themselves heard.
What about resource barriers to participation? So there are these kind of, information and knowledge barriers that we've now talked about a number of times. And I think, probably in a moment in which I'm not sure, Dwayne, if the listening sessions you're describing have been in person or, on Zoom, since if you've only been there since March, I imagine a lot of it's been on Zoom, but maybe they've been in person too. But I think either, so maybe the resource constraints of kind of travel and time and those sorts of things are lessened if we're talking about, participation via Zoom. But I guess just, what are there ways agencies need to be mindful of and could, respond to the potential resource disparities? Again, the big ones I think are, big, organized, regulated entities are just going to have the resources to track proposed rules and to get together, very professional, long responses. So that, sort of stipulated there's that problem, and figuring out how to counter it or to, provide for broader input is something we've been talking about. But I'm also curious about kind of just general obstacles to participating in agency processes that are, kind of brass tacks sort of resource limitations. Dwayne, have you found that people that is that a problem in sort of getting participation in the sort of outreach work you're doing?
Yes, it is. I was trying to give my colleagues, hoping they would jump in, but I when you were asking the question, I thought about several resource concerns, and yes, all of these things that we're talking about, we're just getting to a point where we can actually go back into the offices and have face-to-face interactions. And I was telling some folks, in 2020, I spent the year pretty much alone, and I spent this year pretty much in a remote environment. I'm wondering if I still have the social skills to even function in an actual office setting, but I look forward to it. So yeah, the logistics around getting people together can be a resource. And when you're talking about communities where you have different levels of engagement with, social media, internet, based, web-based activities, that information access to technology can be a serious resource concern. But there are other ones I think that we've experienced. Trust, whether or not the people we are trying to reach fundamentally trust not only the process, but kind of the outcome. If they understand what we're trying to do and trust us, the logistics that we already talked about. And then a serious one is the urgency of the fix. I mean, if I'm talking about flood relief resources in the middle of a drought, it's probably a disconnect, But if it's raining and raining and raining and the waters are rising, I'm going to have a more captive audience. And so at USDA, unfortunately, we have some disparities that put us in not necessarily a panic situation, but certainly an urgent situation. It's urgent that we get this right in order to sustain a diverse set of customers in world agriculture. And that sets the stage. but it can also be a concern too, because people have to balance taking away from the operation to participate in the benefit, which brings us back to the relevance and importance of trying to get this right. But those are some of the resource concerns that we've been able to work through, or had to work through, and really relying on, in a lot of cases, relying on some third-party people to help us either collate customers in a point where they can, get access to reliable internet service, or even just collate people to have a captive audience for us to engage in meaningful conversation.
All right, well, so, we're reaching the end of our time. Maybe I'll invite folks, if you want to take another minute or two, you've all, worked and thought a lot about these issues. Maybe I could just invite you to make, if there are things that we haven't touched on that involve, again, either sort of dynamics or specific proposals that kind of are important ones to leave folks with, or just any concluding remarks with respect to kind of what agencies are doing or should be doing, to achieve broader kind of participation and input in supplementing their notice and comment processes. I will turn it over. Maybe Reeve, I don't want to put you on the spot, but maybe I'll have you wrap first, and then we'll just sort of go through the group, because I don't see any questions in the Q&A. So I'll just give you all the last kind of minute or two apiece.
Wonderful. Thanks, Kate. So I'd actually like to build on something that Dwayne just said. I think was an excellent point as to sort of the different types of, potential resource constraints. And I think it sort of goes to, kind of the fundamental question we're discussing here. So I think, as a general matter, the agency should try to make the process of participating as simple and as straightforward as possible. But there are sort of limits to what they can do. And I think that, goes to sort of the technocratic and democratic thing that we discussed at the outset, that, for certain types of rules that are highly technical, the agency should ensure that the rule NPRM is written in plain language and it's as accessible as possible. But there may be instances, like let's just make up an example. If it has to do with arsenic content in drinking water or something like that, at least me as a, stakeholder, I wouldn't have a whole lot relevant to say to that. I don't really have much expertise in that space. And I think that'll be true of the vast majority of stakeholders. It's probably only going to be scientists or groups that have, extensive expertise on that topic, who are going to be in a position where, at least on the technical issues, they can easily weigh in. But for other types of rules, I think that the public's reaction, and in some cases, the public's opinion as to, how the agency should be proceeding, is highly relevant. And I think, we've talked about different possible supplements today, and I think those are all very, very valuable. But I think another important aspect of the discussion is there are things that agencies can do with the system that they currently have to try to, make it as broad and as accessible as possible. So, for instance, Karian talked about regs.gov and sort of, making it as user-friendly and as straightforward as possible. So that people can log on and they can understand the process, understand how they're, what they're supposed to do in order to participate. There were a handful of recommendations we at ACUS made in connection with the mass comments recommendation, where at the very least, the agency should provide some explanation of, what each rule is and what they're looking for, the type of input that they're looking for. And I think that makes it a lot easier for members of the public to actually understand, how they can be helpful, what type of information they can provide to the agency. And then there are a handful of supplements as well that are really relatively straightforward, putting it up on social media, being as transparent and as open as possible as to what the agency is doing, and try to maximize its footprint in terms of the people it's reaching. And at least resource-wise, I think these are much less burdensome than, some of the supplements that we've discussed. Though I think in a handful of cases, the supplements can actually be very, very valuable in terms of getting the type of informed public input that could be useful to the agency. So I think the most important thing, at least from my perspective, is the agency sort of take it on a rule by rule basis and decide what they're looking for and how do they maximize the probability of getting that sort of input.
Great, thanks, Reed. Eduardo, do you want to go next?
Yeah, sure. Thanks so much for this. Should start with kind of making sure existing tools are working as best they can, take the low-hanging fruit, and increasing transparency and accountability can go a long way. I guess something to add to that as we kind of take the next step, thinking in the medium term, is just we want to be able to lower those barriers to participation, but also preserve the kind of robust engagement that we've all talked about as being really important. And especially when we move to the online sphere where people are going to have lots of habits that aren't especially conducive to really robust engagement, informed discussion, and that ends up imposing a further burden on us all. So we have to balance lowering that individual barrier to getting involved with also not imposing too big of a collective burden on all of us, because we all just can't spend the whole day looking at proposed regulations and responding to them. And that's going to require some degree of targeting or some creativity in how we think about public input to balance those two goals.
Great, thank you. Karian, do you want to go next?
Sure. Yeah, no, I echo everything that's been said. And I do want to sort of emphasize that I think, one thing that agencies could be doing better now is thinking more broadly and creatively about whose voices matter, whose voices will be useful, and really trying to look beyond the industry, look beyond the regulated party to who's going to be affected by the various rulemakings they're engaging in, and trying to reach those communities in all the ways that we've been discussing and what even Eduardo has just said, using current tools, using additional tools, but really, thinking about the constituency from a broader perspective.
Great, and Dwayne, you'll have the last word.
I feel like I've talked enough. No, just great comments. The only thing that I would emphasize, I guess, would be a good self-evaluation, with the central question being, who is if we look at our current rules and regulations and our ability to reach our customers, however you define those, who is not being adequately represented here, and how do we solicit their input on how we improve this process? I mean, just taking on that mantra, I think I do it on a regular basis now, and it's just something that kind of changes the way you shift so that it's more inclusive, not necessarily urgent, but more inclusive to think really seriously about how you solicit input from those that should be represented who have been left out of the process.
We're at time, but I see one quick question from Jim Tozy, which I want to, if anyone wants to speak to this, actually interesting question. What are the federal agencies going to do to support the Democracy Forward proposal regarding regs.gov? I don't know if anybody, anyway, I take that obviously as a strong endorsement, Karian, of the proposal, but does anybody have a sense of whether there's likely to be any sort of agency support for that proposal?
Well, I can just say, and I've not been the person engaged most directly on this, so I can't give a whole lot of detail, but I do know that GSA has done some listening sessions of sorts in response to the letter, and is at least in some way thinking about reviewing the process. I don't know exactly how far along those conversations have gone or what will come from them, but I do think the agency is taking seriously the complaints that we raised.
Great. Okay. Well, thanks for that. And thanks for the question, Jim. Okay. Reeve, Eduardo, Karian, Dwayne, thank you so much for a really excellent discussion. That concludes our panel and today's forum. Thank you again to the panelists, and thank you all for joining.
Thanks, everyone.